Hi, JC.
Good evening.
How are you?
I'm good. More of the same. Stories about... just more stories, Pete.
IRS.
Something.
Mm.
Actually, it's not even them. It's the DOJ and the courts. That's the real issue.
Are we on?
IRS.
Yeah, some people. I haven't seen Christian yet.
Oh.
Actually, I've never seen Christian, but I haven't heard him yet.
It's 3 AM here, so I'm a bit dormant.
I wonder if we're going to have the call tonight.
Yes, I'm here.
Hey, Christian.
Hi, Jason. Hey, Christian. How's everybody?
Hey, guys. Hey, guys. Simon.
Hi, Christian.
Hey, Peter.
Are you well?
Tired. Sounds like somebody else is tired, too.
Hello? Can you hear me?
Yeah.
Oh, okay. Yeah, what was I going to say now? Yeah, I was going to talk, and then I noticed the call was dropped. It's one of them ones, you know, where you're talking for 20 minutes and then you realise, oh shit. Made loads of progress in England today, England and Ireland anyway.
How's that?
Well, over the last sort of few days, I've been concentrating on working on how to access whichever fund that they use to run United Kingdom, you know, which they use my name for in my instance. And yeah, it does seem to be a trade secret. So I'm going to have to organise that. And so that was good. And they have something here called restitution in blood, which is Houses of Parliament, which is the equivalent of your, like, Senate or Congress.
Uh-huh.
And they have these private laws that you can find on the internet, and on the internet it says, is it Denisites? I don't know what it means, I've yet to look it up, but another term that it uses is restitution in blood, which I think is when, you know, they actually get back on the list to receive the benefits or the payments from the Queen, which would be from the fund. So I posed the question to the Houses of Parliament, and a guy came back and said, oh, it sounds like a legal term, you'd have to seek legal advice. We only deal with what goes on in the Houses of Parliament. And he was really swift to reply, like. So I wrote back and I added some links, Houses of Parliament links, where I'd actually found the term, because you can't find it anywhere else. And so far nothing.
Well, that's like over here. We have like the statutes and codes which are put in the Federal Registry and stuff, but if you really want to get the real meanings, you got to go check out the annotated versions of the code. Because in the annotated version, there's stuff in there that's not in the regular one. So you like your statutes at large and things of that, you know, but the regular statutes and codes, how it's listed, is leaving things out, and it's really listed in the annotated versions.
Well, what would statutes at large mean, if you wouldn't mind, Christian? I've not heard that term before.
Well, it's supposed to be the real law if it's listed as statutes at large.
Like common law?
Well, I don't think there's any really common law since after 33, so there really can't be because no money. But, you know, they like to say, you know, unless the statute is placed in the Federal Registry at the statutes at large, then it's really not law. But then what they put in the regular publication that everybody sees is not really the same thing as what's in the versions.
Yeah.
There's stuff in there that explains things that is not in the other one.
You know, England doesn't have a written common law, do you?
Well, actually, common law should be easy.
Yeah. So like 2. We don't have a written law, and we don't have a written constitutional law. So I don't know how they work that out.
Okay.
So, yeah. Sorry?
I started the recording, so we're recording now.
Okay. I was just going to say that about agencies. I'm looking into how to untie the bind that agencies have, you know.
I think it's trust is trust. That unties their capacity.
Yeah. Interesting stuff. Cheers, Christian.
Background, so let me mute out there. It's playing the music.
Christian?
Yes, go ahead.
It's Jacob. How does when they have a new ruling in the court and that sets a precedent for them to use after that point in time, and from what I understand, they copyright that precedent on a daily basis, and then they use that for law form or for the court system through the International Bar Association, through all the association bars. They have to comport to that copyrighted precedences that they copyright. Does that mean anything to you?
Yeah, if you listen to the public, you're copywriting it for them.
Yeah. Okay. So if you
like a bad case law against common law. So.
Well, I guess the thing I'm trying to get at is how do you set yourself up under the trust law of 1776? You just have to express it formally written.
In chambers.
Well, that's the only way.
Yeah, that's the only place where the substantive rights of the real man is in chambers.
Well, but don't you have
all about form, process, and procedure, and the substance of their substantive rights are in chambers.
Okay, but don't you have to? I mean, don't you want to put that on each document that you?
You do that your way, because under the federal evidence, 501, and then comports down to your local states. But Florida, 90.506 and 507. 506 is the privilege matter with respect to privilege, and that's the protective order that goes on that. And then 507 is the waiver of that privilege matter by voluntary disclosure.
Welcome to Revelation on Record. I'm your host, William.
Yeah, so
voluntary what?
Voluntary disclosure. So when you bring it into the public talking about it, you voluntarily disclosed it and you waived it.
But how if you're going to make up a document in order to be able to stand on that law form, don't you have to make mention in your document that this document is created under that law form as well?
Yeah, but just enough notice in the public side, and all my substantive rights and things that I'm claiming are on the private side, and that public notice points to that private document stuff that's got the protected word.
So the UCC1 and when you record it in the county, it has to have some kind of mention of that. You mean?
Yeah, that's what we do. We use an RA number to mention the fact that this RA number represents privately held documents which list all the details and the specific material facts that is privileged and protected.
Oh, so we don't mention it. Okay, so on that notice, you don't state that those documents are under the 1976 law or 1776 law form.
No, not in there. No, that would be an in-chamber substantive right for the real man.
In a DIB hearing.
Mm-hmm.
And the DIP hearing is where?
The in-chambers hearing that you're going to bring in your
in-chambers DIP hearing, okay.
Mm-hmm.
If you were going to work on your IMF file, you have this form that's been being discussed, how you fill out this form, and you want to fill out this form for them to make known your position. But could you do it in an opposite way by making up a questionnaire and then asking them all those questions as opposed to making statements so that you could get from them?
Well, that sounds like an interrogatory.
Oh, is that what that is? But can you do that? Like the
yeah, put interrogatory into discovery rules, yeah.
Supposed to.
But you just can't write.
Chris, I don't know if he was done or not.
You just can't write them a letter.
No, letter is worthless to the.
Huh?
A letter is worthless to these people. They don't have to respond to any letters at all. If you don't put it in an affidavit form, make some kind of administrative process, private process out of it, and then later on bring it in chambers, you're not going to be able to enforce it.
A lot of your questions are on old tapes. Maybe you should listen to those.
Okay.
Christian, I got a question.
Yeah, who's this?
This is Darren.
Aaron, hey, go ahead.
How you doing? Yeah, now anytime when we're doing the UCC1 and basically expressing the trust as, of course, grantor settler, do we also do a UCC1 coming in as beneficiary also, which is a separate one? I think you mentioned that last week.
Trust. If you want to terminate the trust, yes, by merging the two.
Oh, I see. Okay, only when you want to terminate the trust, that's when we do it. Okay. Let me think. Okay, that was really the only question I had at the time, and also too, and let's say you're in a current court case, you could on the UCC1, you could always put the court case number that you're just making the notice of. You're not putting any information in regards to who the trustees are or anything like that.
Yeah, you could just use the case number if you wanted to as that specific res identifier.
Okay.
But I like using an RA number, to point to that because I can encompass a lot more in that RA number that maybe it might not be encompassed in that case number.
Oh, registered mail?
Yeah.
Creates a title, right?
Or private that way, too, because nobody knows what that RA number stands for. They come to me.
Are you familiar also, I've been doing some reading on some commercial liens and some process in regards to putting certain stamps on certain documents, which kind of initiates the UPU jurisdiction internationally, where you got to put stamps on the front and then some on behind of pleadings. Are you familiar with this at all?
Yeah, but that's debtor creditor statutory in an international venue.
Okay, that has nothing to do with from like an offensive standpoint where you're going after them.
Well, it does. Like, it takes the authority more or less out of their hands locally and now puts them on an oversight of someone else, say in an international venue. Now, if those rules that international venue is operating under, if I know what it is and it looks like it's going to help me, yeah, then I could use PU as a statutory public side entity that would do my bidding for me, so to speak, because I knew and understand what they were going to enforce, and they were going to enforce my side on.
Okay. So let's just say something. Let's just use a hypothetical. Let's say in regards to you had an issue with, let's say, a state agency, and you wanted to go after them. Even though they didn't have a claim on it, you say you wanted to go after them, and actually not only stop what they were previously
doing. The IRS doing their job. Who are you going to get that's got power over the IRS to make them do their job? So I might have to go into a higher international venue to, get something over on them to force them to do it.
Well, the common law court is the highest one, and a court of record, which technically is also
Court of Equity is the highest court. Page, page 19 on the law treatise here. I think it's...
Are you saying that that supersedes the Magna Carta from dating way back to common law? Because that's the sovereign's court in a court of record.
Yeah, it goes all the way back to the trust that God gave to Adam. Because that was equity. It says here on page 16, it says, equitable estates and rights are now to be noticed and acted upon in all courts, and where there is any conflict between the rules of equity and the rules of common law, the rules of equity are to prevail.
What page was that? I'm sorry?
Page 19.
Okay, thank you. All right, I'll read that again. Okay.
So your equity court, your equity is highest law in the land. And really, if you stop to think about it, that's really right, because equity goes all the way back to when the trust was granted to Adam, and that was equity.
I'm just, but there, I guess there's technically, is there such thing as a common law equity court?
Well, there's two sides to it. You know, before 33, there was two sides, common law side and equity side.
Yeah, because, and that's normally, isn't that normally how also you do the heading of the paper in your pleadings, because one is referring to equity and the other one's referring to, like, an injured party.
In your law form, whether it was common law or whether it was equity.
And when you do it in the middle, it covers both.
When I do it in the middle, how do you mean?
Pleading. You know how, like, some pleadings, you stay them to the left-hand side, which refers to, like, equity, but then there are some that even that go right in the middle, because even the opposite side is to be referring to, I think, an injured party, which, of course, you have to have an injured party under common law, which most of these courts are operating today is under the APA, the Administrative Procedure Act, and they're acting administratively because technically many times there's not an injured party, and they're going by under rules and statutes and codes.
There can't be an injured party because we don't have any money to put a value on an injury. So technically you can't put a value on an injury and then it's valueless, and then there really is no injury. So you can't have common law injuries. So that's really a lot of people don't understand the ramifications of what happened, what really happened when we took the money backing out of the currency. That's a concept that is by some people really bad. That
you mean what Nixon did took us off the gold standard?
Yeah, the gold standard. Yeah, when we talked of gold backing out and the silver backing out of the dollar. Because that was what you have a common law remedy because somebody did a common law breach. To get a remedy, common law says you got to get paid for damages. If there's no money, how are you going to get paid? So therefore, you have no remedy. You have no common law.
Mm-hmm. Or you get them paid in debt notes. FRN.
That's not a common law. You have to get paid something of value designated as money, $1, backed by gold and silver.
Correct.
So here all along we've been thinking happened under Admiralty, although it looks like Admiralty, but here it was really all trust.
So really, technically, I mean, how can we really look at a remedy, even from a financial standpoint? And you know what I mean. I know you're talking in technicality that no, there is no money, you can't get a remedy because of this. But in technicality, what you're trying to do is normally on where if you really have been injured technically, and somebody has basically impeded on your rights, and you do want to have some, especially if there has been some type of an injury where there's been either loss of income or someone has actually injured you, and you're seeking some type of monetary position
with money. See, we are totally operating in fiction land in Oz, and we don't really grasp it all yet.
Mm-hmm.
I mean, how can it be anything of value unless there's something, some standard of value to measure it against? Before we had a standard being $1 being worth so much weight in gold. But now, if a dollar is nothing more than a promise to pay, well, how can you pay anything with a promise? What is the value of something measured against a promise to pay, or a promise to be something? You know, it's just, you know, it doesn't work. We're totally in Oz and don't know it.
Yeah, but even though those promises to pay basically have sustained us in regards to where we go to the supermarket, even though we're doing promises to pay, it has still sustained us, even though technically it's not a standard or a value, but it still has technically sustained us in a way.
That's the confidence. That's the con game. Confidea.
So,
right. You've been conned into being a victim, really, the convict. And the confidence, or confidence, confidea, is living, is con, and fidence is faith, living by faith. That's confidence.
But shouldn't we have some kind of remedy to offset something in regards to like where we have been injured or have been damaged and we want to go after a party on an offensive output? Shouldn't we be doing something? I mean, other than stopping what they're doing, which through trust technologies, kind of really separates you from that straw. But can't we really institute something on more of an offensive level? Because, as they say, a good defense is a strong offense,
That's why I keep stressing that in equity under the trust, you have a greater power upon enforcement of somebody preventing them from breaching the trust.
Mm-hmm.
You got a way to beat these people up and get them to force them into doing what they're doing through equity and trust to prevent them from breaching the trust. The court of equity will force them not to breach the trust. Now that's your.
And if they've already breached a trust, even though you're saying it has to be expressed first before the breach can occur, right?
Yes, he who claims trust must prove trust.
Even if they've been operating as a trust from the inception. So let's say, for an example, you've been fighting a case for 5 years, and now you realize through everything that you've been doing, oh, this is a trust. But now you see it, and you're saying, hey, they've been operating like this for 5 years. Technically, can you go after them for breach of trust from 5 years ago, even though you just expressed the trust today?
Yes, because the present notice reflects back to a past tense, present transfer of trust res.
Perfect. Okay.
And whenever it was transferred, although it was 3 years ago, or 5 years ago, or 20 years ago, or even 100 years ago, it still was a fact then.
Okay, I understand. That makes it clear. It does make it clear.
When did the present transfer of trust res property happen? Could have happened 3 minutes ago or 30 years ago.
Mm-hmm.
But
you're just making notice of it.
Yeah, make some records of notices of it and notice it in the public.
Mm-hmm.
Right.
I'm sorry you broke that.
I don't have to. Equity's going to enforce it for me, because as soon as I set up a trust, and they're the trustee, say, once a beneficiary makes a prima facie claim for a breach, a trust breach, the court of equity automatically assumes that the trustee is guilty, and the only way he can prove himself innocent is to come up with a record that he made a payment or disbursement.
I was just reading that because
power of the court of equity under trust.
But you have to always go to court to do that.
Proof shifts. The onus of probandi shifts from to the trustee to prove, and the only way you can prove is against the indenture, what the indenture said, whether he was operating within the indenture crop, or whether he had an out under the indenture, or whether or not he made a payment. And equity is going to assume that he's guilty.
And that's, I just read that. It was talking about private law is civil law, and you are presumed guilty until you're proven innocent, which versus the common law, which you're innocent until proven guilty.
Yes, right.
Wow, that just re-emphasized what I just read.
That be to force you, to compel you not to breach the trust, or to get you to do the duty that you breached.
Wow,
it has to presume that you're guilty. And then if you are presumed to be guilty, you're guilty, you better have a record that you made a disbursement or a payment.
Now, when do you claim the trustees? Is that in 3, the UCC 3?
When do I claim the trustee?
Yeah, in other words, when do you name the trustees? You set up your UCC 1, you're making a notice. Is it the UCC 3 where you actually name the trustees?
Well, in the transfers of the setting up of the property, when the actual trust was formed at the present transfer, who got the trust property? It has to be sent to the trustee. So the trustee had to be identified, whether or not you named him or not, but you identified him by giving him the trust res. So you had to have identified him when you formed the trust, and when was the trust formed? The present transfer of the trust property.
Okay, so that does have to be a part of your UCC 1.
Well, it is, but it's there. It's implied, because who got trust property? Who'd you send the trust property to?
Well, you have the debtor creditor.
Then your trust wasn't formed.
Okay, yeah, because you have debtor creditor on 1, and then on your 4, you're the secured party, which you change on 7 under grantor, settler, and then, it goes under trust, and then later on you correct the number 4 to grantor, settler. But then you should be naming
the settler, because the EE or the trustee, the grantee or the trustee is first / grantor. Because my block 1 and 2 are my trustees or my debtors, and my block 3 is the secured party or the grantor. So what's 1? 1 is trustee, so that has to be on your line down below, a trustee / grantee. Grantee or trustee / grantor.
Okay, and the good thing is if you make a mistake, you can always amend that, because I think there's a separate form saying, well, I misinformation here, and here's what I meant to put in it. You can always correct that, correct?
Yes, you can always go back and correct it, yeah.
So that's it, is just understanding that exact format where everything goes.
If you look at the block 5 where they list the bailee, bailor, it's EEs first, bailee. That's the same as a trustee or the debtor.
Right.
And the / trustor or bailor is the same as grantor or trustor, settlor. And that's your block 3 secured party.
Okay, so it's a trust, so it's the trustee is named first, and then the trust itself, which is the trustee.
Block 1 and 2 goes where the debtors are.
But that's normally the straw, isn't it, the debtor?
No, there's no straw man on that form. Well, they're all straw man on that form, but really it's the straw man trustee, the straw man beneficiary, the straw man grantor,
Right.
On those forms, but...
Okay, so you got to name the trustee in the 1 then.
Yes, because how would you transfer trust property to him? He'd have to be named.
Okay, understand. Okay. I made a boo-boo. Like I said, Christian, this is like learning a new language, and sometimes I no habla.
Can you summarize that?
But just don't ask me to spell it.
Hey, Christian, it's JC. I have a question for you. A question started coming at you right away. Did you have an agenda for tonight that you wanted to run through?
Well, I had a few things I wanted to talk about, but that's okay. We can continue on with questions.
Okay. I just have an input on that last conversation about the UCC1 and being proactive when you're going to litigate with somebody and take the offensive. When you are choosing your trustee, grantee on that, whoever you're going to choose, you probably want to make sure that they're within the jurisdiction of your district court, at least within 100 miles, at least for the U.S. in the Federal Rules of Procedure. If you were going to try and sue somebody or subpoena somebody outside 100 miles, you're probably going to have to go to that other district where they're located, open up a court case, and then get jurisdiction over them. So to make your life easier, you probably want to find a trustee that's relatively close to you, and that. So that's just a procedural thing. But then it begs the question: if you are, say, for example, if you're in a matter with an agency, can a lower level agent be the trustee for one of your matters to hold those documents or that res in trust for you? And does that lower level agent have the authority to settle and close all matters, or is that even an issue?
Well, if he was trustee, yeah, you could have a local agency do the trustee, and it depends on the scenario whether or not it would be a real issue or not, because you'd have to put some examples on that, how that would play out.
Well, say for example, you're dealing with an IRS matter, and you have a local revenue officer that you're dealing with, but we've talked about sending to Rios, sending to I guess some other departments the res for closure on that piece. If you sent documents to like in a private administrative remedy, whether it's the commissioner or the CFO or somebody at the high level in D.C., and you try to run an administrative process against that person, if you try and turn that into a res, you're going to have difficulty, because you're going to have to actually open up a parallel court case in D.C. and then get them served, and then it's a big process. Whereas if you just do that with the local revenue officer who maybe was dealing with you initially, trying to subpoena you or serve you with documents, that local officer may or may not have the ability to settle the account. It may be outside that person's jurisdiction at this point, maybe outside their scope of authority, delegated authority to settle any matters. So they might take the trust res and just send it off to Ogden or D.C. or somewhere else, and all of a sudden now they've breached the trust because they're supposed to hold that in trusts for you, or give you like kind back. But again, they of course they didn't know about that, so that's okay. You can still take them into court, but whether they have the authority to settle a matter even though they breached trust, that it becomes a sticky matter. They could just disclaim that they don't have any authority to do that anyway. So even if they did breach trust, it still leaves you remedy-less.
Right. How about this scenario? If I wanted to play the trustee route myself, now I've got the ability to make the payment. So I make the payment to, say, XYZ Bank, that is a credit card situation, say. I make the payment to pay off the credit card with my payment. So I'm treating it like a trust. Since I've made it a payment, it makes no difference whether I appoint them trustee, say, on this, because really I'm going to play the trustee route. And they don't have to settle and close the case because I've already closed it as trustee. I've already made the payment. And now all I'll do is take my records and documentation of the trust that I've formed and everything, send all the documentations of the payment up to the IRS, and let them contact the XYZ Bank.
Yeah, I like that. That's a good position for a third party. How would you do the same with if you had an IRS matter with they send you a presentment? You want to settle and close that, or close and settle that rather. You can do the same thing, but then you don't have the IRS to come back in and support you on that. They have to do it because you directed them to, and they may or may not do that.
Right. So the right hand of the IRS is sending you a bill, and then I want to make sure that I pay it, but I'm going to pay it, and then back to the right hand. But But then I'm going to take the records of my payments and stuff as trust and send it to the left hand of the IRS.
Mm-hmm.
And the left hand would be the private side.
And that's where the matter comes in of the enforcement. That left side, when you send that to the private side, that's going to be in D.C. And then if you open up a court case and you try and enforce that, you come in as trustee and say, listen, I already made payment. They're not closing and settling us. They've already breached trust. Again, then you're going to have to open up a separate court case in the District of D.C., get them served, and subpoena them and have them come down and demonstrate as to why they haven't closed and settled the matter, why they've breached that trust.
You could do it that way. Yeah.
Well, from a procedural way, that's the way you have to do it, because you're going to send it to D.C. and you can't, if you open up a court case in your home of record, wherever that may be across the country, you can serve them with a subpoena in D.C., but they'll just throw it in the trash because there's no jurisdiction. So you have to spend the time and effort and find somebody, go out into D.C., open up a court case, and then have them served with a subpoena, have them produce the records, and show why they breached trust and why they didn't do what you asked them to do, or directed them to do, rather.
Mm-hmm. How about calling a dip hearing in the IRS itself first, under the 25-06 dip hearing?
When that's a point of discussion. Whenever you say when you call a dib hearing, to me that's a letter that you are sending. You're directing them to fix the records. You're not actually asking for anything to be done other than correct the records. So, you'd send your evidence of what is in the public. Of course, that has to be colorable, because you don't want to release the private stuff to any third party, even if it's a third party within the IRS. So you'd send them the evidence of that payment. You'd send them the direction, and that's it. Now, how do you enforce that?
I'll put that Treasury Directive 25-06 up on the website. It's up there now, along with the U.S. Attorney Manual 6-010. That's all in together. But that's your dib hearing right there. I would call the dib hearing, put the information in after I claim the trust, and put the records in it, approve the trust, copies in it, and tell them that this record is being construed and the master file is all wrong. Here's the record.
So now we're going right. So now we're trying to correct the master file with that. And it's not just simply an intermediate presentment, a bill collector or the IRS sending you a bill saying you owe $48 for tax year 2005. Now you're trying to correct the IMF, which is a different matter.
Yeah, I would like to have the IMF master file be the actual dib hearing under an Article 3 court. That's really my court, because I'm the one that's putting the records in there that all of the agencies got to comport to. So that's our true Article 3 court right now today.
It's not in D.C.?
No, it's in the IRS, individual master file. If the master file records, everything that's put in there, all the other agencies got to match up with. Who's the party that puts the information into the master file? We do. So all I need to do is put the correct information in there, make the correction, and order them to do the dib hearing, and all the other agencies got to comport to that information that's in the IMF.
So in essence, we are the king and instructing them what to do.
Yes.
Well, what is the correct information?
Wait a second, though. That goes back to my issue about enforcement. You're going to direct them to do something. You're going to send them your evidence package of what you put out in the public, and that's your supporting documents, whatever compilation that is. But then again, you're directing them to do something, and like we've seen so often, you can direct them to do something with paper, and they can disregard it 10 different ways. How do we enforce that dib hearing and the correction of the records in the IMF?
After that, then you might have to go into the DC and do a court action. But I think I would do the 25-06 dib hearing first.
Mm-hmm. That I've read that 2506 a couple times, and again, that really is the establishment of the Data Integrity Board for the IRS, and it establishes the main parties, who the CFO is going to be. The CTO is going to be the chairman of that board as a permanent member, and then there's 2 or 3 other members that are I think also have permanent seats. But that 2506 just establishes the fact that there is one from a high level standpoint. So really all we're doing is not that we're calling, I guess we are calling our own Data Integrity Board, but really we're just directing the CTO.
It's called it's really a TD, a Treasury directive. So it's TD 25-06. So a directive is really a direction, a decree. You're really declaring, or you're using non-precatory language to order this dib hearing, and ordering them to correct the records that you've established, and there's the correct records, and do the job.
But who would you make the trustee, especially if you're named as a defendant? You don't want to be trustee if you're as a defendant or respondent. And that's who they always nail as trustee.
Well, it's true, because the trustee, he's the recipient of the records, and he does the ledgering into the record-keeping books, supposedly.
So who would you make?
Well, I really like being trustee under certain situations, because the trustee's got the ability to make the payment. And if I'm making the payment, then I'm actually making the beneficiary solvent. I'm paying the debts. I'm not, when you pay debts, you can't be technically classified as insolvent or bankruptcy. So as long as I'm making my payments, technically under Black's Law, insolvent means that even though you have the assets, you just stop paying. And if I had the assets, all I got to do to change that situation is to start paying again. Now I'm not bankrupt.
You keep mentioning payment, and that is through a directive to get into, the account. Is that correct?
Yeah, but technically, since we stopped making payments, since they took the real money out of the backing of the system, now we went technically all bankrupt because we stopped making a payment with real money.
So this goes back to originally we have to do the original IMF and then do the Declaration of Independence and everything else and get that all squared away first before we go into a court case and turn around and say, well, we're directing you to make payment, or we've made payment.
Well, your action, I'm saying that your action that you're trying to make a payment actually makes you solvent again. So you can't be classified being bankrupt or insolvent because you have stopped making payments.
So just by your actions...
As long as the Federal Reserve knows we can never make a payment, we are technically locked into bankruptcy. But as soon as we start making payments with the real money, the private credit that's being held in the private, now we're not technically insolvent any longer. We're making the payment.
And where's the private money?
It's in an account someplace. I don't know where they got it for. Yeah, it's in the Federal Reserve.
How can you pay it if you don't know where it
is? The money is connected by, say, a string of accounts, and I don't care how long the account string is, it still has to lead to someplace.
Well, don't we have to have proof of that?
Oh, no. The proof of it is really House Joint Resolution 192. If you gave them something, what did you get back in return? You got an IOU. You got a trust receipt.
So by our action or our words, when we instructing them to make the payment, then that will be taken as that we're not insolvent anymore. Is that correct?
Correct. Your actions speak louder than your words. So if I acknowledge the debt by saying I want to make a payment, now that stops the prescription. And the prescription is bankruptcy. Now, this could work on a smaller individual bank situation. Say we were trying to pay a credit card debt and clear it all up. It might just work, but just like you said, it could be that we might have to go in there and correct the whole thing and get it pulled out by the root from the beginning.
Christian, when do you want to start that process?
Well, we're going to do it in the workshops.
Exactly.
Well, this last week with JC and Eric, we were coming together with the protective order. We were going over that. So hopefully we can come to a conclusion on that and get that information to you that you've already sent to us.
Okay, all right. I just put a note down there. I was going to put that protective motion order up on the website. So
when might you start the?
Yeah, I think that protective order is done as far as, like Eric and I talked earlier, right? That's just in the public. That's just asking for protection against the CCI that you're going to put in. The real thing is making sure that the CCI that we have is labeled and such, declared as such, kept in private. We haven't violated it. I mean, the document that you and I kind of went through based on O'Connor's 2010. I used that document in one of my cases, and the court ruled against it. But at least I put it out there to test it. So as far as I'm concerned, it follows their guideline. It's all that you need. And then, of course, I didn't take it up on appeal because I didn't feel like that was it was something that I needed to do. I didn't need an interlocutory appeal on that matter. So I let it go and let the judge overrule that or rule against that. But from a protective order standpoint, I think that's all that you need.
Did you ask him for any conclusions in law? Why he overruled it?
I haven't done that yet. I'm pretty busy with a couple other documents, but yeah, I will do that because they're going to have to stand on that at some point. Basically, she, in a short paragraph, all she said was, I don't see anything in here that needs protection. And in part, in her defense, I didn't have, at the top and bottom, I didn't have anything that labeled it as commercially confidential or sensitive or trade secret. And that's going to be one of those acid tests. So in all the documents that we put out there, we're going to have that clearly labeled and then protect it accordingly.
Probably was right when they were ruling what she said then.
Right, exactly. So, I understand that. That's another reason why I didn't take it up on appeal. But it's a learning point, and I'm happy to be learning on this in this format. But it just speaks to the fact that we need to make sure that, and there's 3 or 4 sort of acid tests that the court, when you look at trademark, patent, and trade secrets, how you protect it, what measures you use, who had access to the documents, how it was labeled, all those things come into play. But from a pure document preparation standpoint, from my perspective, that protective order is done, and the memorandum of law is done. That's not rocket science. The real issue is what we do with our documents and how we protect them and how we get them into court.
Mm-hmm. Does anybody have I have an Aspen book publisher's book called Florida and Federal Evidence Rules. And they also make one for New York and Federal and Texas and Federal. They make 2 others. But this little book here really explains the reasons for the protective order.
Isn't that on your website?
No, I didn't put the title of it up there, and I don't have any copies out of it, but I might want to copy some of the sections out of it, because it's really not that long.
Can I ask one, pardon me for interrupting there, you got all the way from the page 19 earlier. Was that the law of freeze you said?
No, that was the Practical Treatise on the Law of Trusts by Lewin.
Oh, okay. Thank you.
I went through this on one of the previous shows, but this 90.506, which this is the local state Florida rules evidence here, and that comports to federal under 501. It says here, a person has a privilege to refuse to disclose and to prevent other persons from disclosing a trade secret owned by that person if the allowance of the privilege will not conceal fraud or otherwise work injustice. When the court directs disclosure, it shall take the protective measures at the interest of the holder of the privilege, the interest of the parties, and the furtherance of justice required. The privilege may be claimed by the person or the person's agent or employee. And skipping down to the sponsor's notes, it says, when a court orders disclosure, the section provides for the issuance of a protective order. And the protective order under Florida is 1.280C7. So the issue of a trade secret privilege usually arises when a litigant seeks to compel disclosure of secret information which is commercially valuable to his opponent. And the Florida Rules of Civil Procedure 1.280C7, which permits the trial judge, upon motion of a party from whom the discovery is sought, to issue a protective order, quote, that a trade secret or other confidential research, development, or commercial information not be disclosed or be disclosed only in a designated way, unquote, is extended by this session to evidentiary matters at trial. The difference in circumstances at the discovery stage and at the trial may be such to require a different ruling at the trial. I mean, it goes into it pretty much in depth. Let's see if I can find a section here where it says, so under 90.507, this is the waiver of the privilege by voluntary disclosure. A person who has a privilege against the disclosure of confidential matter of communication waives the privilege if the person or the person's predecessor, while holder of the privilege, voluntarily discloses or makes the communication when he or she does not have reasonable expectation of privacy, or consents to disclosure of any significant part of the matter of communication. So it says in the enactment notes then, it says, this section provides for a waiver of the privilege by voluntary disclosure. And there's a case site, Savino versus Luciano, 92 South 2nd, 817, 819, Florida, 1957.
So basically what that's saying, if we write up the protective order right, the judge cannot refuse it with citing the court cases, correct?
Probably if you had the real substantive information to be protected, the CCI, then, yeah, he would have to put a protective order on and recognize it. So there was another case here. It says the defendant voluntarily testified in a deposition to confidential communications between him and his wife and denying the husband's objection to the introduction of the deposition during the trial. The court stated, it is clear that under the law of Florida that a personal privilege may be waived when Mr. So-and-so voluntarily and without objection testified on deposition to the privileged communications they lost their confidential character. A waiver by voluntary disclosure occurs only when the substance of the privileged information is revealed. Thus, when a witness upon cross-examination testifies without objection that he has not made a certain statement to his attorney, he has not waived his attorney-client privilege since the contents of the statement has not been revealed. And then in the commentary on the federal and Florida rule differences, says 90.507 provides that a person who otherwise has a privilege against disclosure of a confidential communication or document waives the privilege if the person or his predecessor were a holder of the privilege, voluntarily discloses the matter, makes the communication when she does not have the reasonable expectation of privacy, or consents to the disclosure of any significant part of the matter. And it continues on to a failure to object to the introduction of otherwise privileged matter constitutes a waiver. See Woodell versus State, 804 South 2nd, 316, 323, Florida 2001 case. When disclosure is inadvertent, Florida law neither views the privilege as automatically waived nor necessarily preserved, but instead follows a multi-factored relevancy test to determine whether the privilege has been waived. And it goes on, it pretty well spells it all out. And if somebody would read that, they would see exactly why everybody is not winning, because they're talking about all this privileged information, and it gets clobbered in court. But that's Florida and federal evidence rules, and they make one for New York and federal, and they make one for Texas and federal.
Where'd you get that?
That's Aspen Publishers, and it's Peter Nicholas. Got it law at University Library. The bookstore. If you have a local university with a law library bookstore, go there and they can probably pick that up right off the shelf. You can probably pick Gilbert's right off the shelf, a lot of that too.
Christian?
Yeah.
It's Chris out in California. I wanted to ask you a question. A couple weeks ago I asked you about land patents. Did you get enough accumulated to where you can do a presentation or send me that material?
I just talked to the person that actually... I got the information, and I haven't fully digested it yet.
Okay. What's it looking like, though? Is it looking pretty promising that the...
Yeah, it is. What I can see is that the person didn't realize what they were doing. They were really operating under the trust, and they merged the two titles and allowed the perfect title to come forward, and they didn't even know it. That actually is what I see happen. That it's happened. Because you start out with like a circle, and that circle being the perfect title. Then after 1933, like you draw a line right down the middle, a vertical line, and now you had a trust that came in and split the two titles. The perfect title now has two sides. It's got the equitable title and the beneficiary on the right side, and it's got the liability title or the legal title and the trustee on the left side. But it's still a perfect title, but it's two titles now. But the thing is held in trust. So you can't bring the perfect title forward until you merge the two sides, merge the two titles back into one, terminate the trust, and now the perfect title comes forward. And the merging of the title was the actual payment. So what the party did was they went into the county and they said, okay, wanted to pull up a record on the thing, and he said, well, that property's been sold. It's been bought by somebody else. And well, who bought it? And then he said, he smiled, it was him.
Interesting.
So how did it get paid? How did it get purchased? It got purchased by the merging of the titles, because the merging of the titles was the payment. So it was all done under trust. It just wasn't realized that he was operating under trust.
So is that kind of like inadvertently? Is that the way a land patent actually clears the property and it's unlienable at that point? Is that kind of like what I'm trying to size this land
forward is the trust.
Say it again.
What's holding it from coming forward is the trust, because it's being held in trust as a split title. The trust split the title. The trust split the perfect title. It's now held in two entities, a beneficiary and a trustee. And therefore there is no perfect title until the two titles are merged again. And when they merge, that makes a payment, and that transfers the property.
Yeah, I see.
Christian, can I ask you a question?
Yes, go ahead.
Can you help me to understand, like in a everyday situation of a trust, as an example, when you're working or whatever, and you make an agreement with someone, and they don't uphold their end of the agreement, whether it's verbal or oral or written or whatever, and it just seems like the commercial remedy seems very simple to get them to default and place a lien on them, where because they're dealing in a credit world, that lien would mess them up, so they'll end up having to pay it, more or less. How do you do it on the other side, from a trust side, to get them to force them to pay you the money they owe you?
Just like we were talking about earlier, when they breach the trust, the power of trust is in equity, presuming that the trustee has breached the trust and is guilty.
But you have to go to court and get them in court and get the judge to do it?
No, we could probably go through the Treasury dib hearing and get the Treasury to adjudicate it.
Ah.
Would that also work on getting access to their private ledgering and accountings of where they've taken promissory notes and have prostituted them out several times over?
I would say it encompasses all things.
That's great.
So Christian, so say can I take an actual real case?
All right.
I worked on an agreement with a manufacturer in Mexico and a manufacturer in Argentina, and I made a deal with them. And I said, I will restructure your manufacturing that you're doing in Argentina and Peru, and I'll move it into Mexico. And you pay me this amount of money. So I performed, and then when I was done, the two parties, because it was two parties, neither one of them would pay. So, I mean, I could easily get them to default and get a lien against their business. So and wouldn't cost me much time or money. So how do I do it I want to do it from a trust, direction. So right. I would go in and
I put the SNEP case versus the U.S. versus SNEP on the website. It's up there. I got the two case sites. One was a fast case against it, and the other one was the actual case.
Okay.
Now, why did the United States, being the CIA, why did they come against SNEP with trust law? Why did they approach it as trust? When they had two signed breach contracts of employment that this guy breached. Why did they come at him under tort law? Why did they choose to come after him under something totally different, trust law? Read that case.
Okay.
Because the power really comes under the trust, because if the trustee breached the trust on a prima facie case presented by the beneficiary, and the only thing that makes a prima facie case is all they got to do is put in an affidavit and make a claim that they didn't pay. That's a prima facie case. Now, a court of equity is going to presume that he's guilty, didn't make a payment. And the only way he's going to get out of that is if he shows a record of a payment.
Can you repeat that, please, slower?
The court of equity, once the beneficiary makes a prima facie case, which is nothing more than an affidavit stating that he didn't pay me. Once the beneficiary makes a prima facie case, a claim, the trustee is presumed in a court of equity to be guilty. And the only way that the trustee is going to get out of that is if he has a record that he made a payment or a distribution.
Okay, so now you have to enforce that, and you have to go over to the Treasury to adjudicate it?
No, I don't have to enforce it. A court of equity will enforce it. The court presumes he is guilty, period. Where's your record of a payment, Mr. Trustee? If there's no record of a payment, you're going to jail, period. That's how they're getting you.
Well, I know you don't like to talk about other sides subject, but just for other people's common understanding, if you were doing an acceptance for value, that is a tendered offer based off of what they gave us as original remedy. That would be what you're talking about here, wouldn't it? If you gave them a tendered offer, like a bonded promissory note or an acceptance for value?
Now, how's that tying in with the trustee being didn't make a payment?
Yeah.
Well, I'm trying to understand what you mean when you say making a payment. Wouldn't an acceptance for value or a bonded promissory note be in lieu of that?
If the trustee didn't make a payment to the beneficiary like he was supposed to per the indenture of the trust, or make a distribution to the beneficiary, if the beneficiary makes a claim against the trustee in a court of equity under trust, that trustee is presumed to be guilty. And now, the only thing that's going to get him out of this situation is if he has a record that he made a payment or distribution to the beneficiary.
And so he would have
Christian. If he doesn't produce a record, he's guilty. He's already guilty.
But that would bring criminal charges against him?
If you could prove willfulness, mens rea, yeah.
What if you defaulted a bunch of parties?
Well, I don't have to default. He's already been defaulted. That's what you guys aren't grasping.
No, but here's the point. Well, what if, let's say, for an example, you're going after some government officials, and even though you've done the notarial protest and all that, UCC won, and you can make actually the state comptroller the trustee, because in essence they're the ones holding the money bag, and then if they fail to pay you for the damages cited, then they would be in the breach of trust, correct? Using that scenario.
Whoever the beneficiary is, if they make a claim that the trustee did not pay them, the court of equity is going to be automatically saying that the trustee is guilty.
The trustee is always guilty in a court of equity. That's why when we walk into court, we're considered the trustees. You're automatically guilty. Period.
The only thing that saves your ass is if you got a record of a payment or a distribution,
which most of us don't have when we walk in there.
That's why we go to jail. We go to jail for breach of trust as trustees in prison.
So, Jacob, you would be the beneficiary. These other guys...
You're muted out there somehow. You lost.
Yeah, we lost you.
Okay, Jacob, can you hear me now?
Yes.
You would be considered the beneficiary. These other guys would be the trustees.
Right.
And they're...
You're muting out again.
Unless they can show the court that they paid you.
Does this Christian, do you have to put this in writing, the trust?
No, a trust can be oral.
It was oral, but I would have to express it in some form to get them to comply, correct?
But when does the trust form?
When we agreed verbally and orally half a dozen times that
no,
they
that's
paid
not a trust.
something. Huh?
That's not a trust. The trust is formed when the present transfer of trust res is actually put in the hands of the trustee. That's when the trust is formed. And you got to create a record of that transfer.
What should be the trust res?
Yeah, it's got to be trust res transferred to a trustee, and you got to have a record of that.
Well, wouldn't a trust res be his providing the service?
It could be. But you see, he didn't point out that. So obviously he doesn't understand trust to prove it.
But he can go back with a UCC and do a non-protect.
Yes, so trust res can be intellectual, which is intangible, or it can be tangible property.
So, Jacob, you can go back. non-pro tonk, and revert back to the input the date.
Yeah, you're skipping out all the time. Something is.
Okay, we're only getting about one every 3 or 5 words.
Yeah.
You can go back to UCC1 and file the date, non-pro tonk, and express the trust.
And in this case, it was intellectual property.
You have to create a record when the transfer of that intellectual property occurred. Something that they can see. 2 records. That's why we do a 1 and a 3.
But
and so on the 1, in a typical business transaction, I'm the grantor and the beneficiary, and I'm entrusting that they're going to pay me when I give them the intellectual information, the trust res, to uphold their word. And so when they breach their word or breach our trust or the trust, and I have the 2 records, which are the UCC1 and the UCC3.
Yes, but the 1 is representing a claim, which you have to have 2 witnesses. The 1 is one of the claims, and then you need a county, which is another record, proving the claiming. Then you need a 3 and another record, a county again, and that's the transfer.
He can do that by notary presentment to Argentina and Mexico.
Well, the guy from Argentina is in California, and the guy in Mexico is in TJ. So it's like an hour apart. It's not that far,
Well, you can do a notary presentment, or if you're going to go to California, then,
Now, what is the payment that you were supposed to get in return?
I was supposed to get 5% of the total business. The business volume.
No. I'm not talking about it. That's like interest. Interest is a portal word. What's my interest? Okay, $50. No, my interest is I own a share of this. That's not what I asked.
Okay.
There's 2 meanings here. There's a double meaning here. And the double meaning is you're construing it under debtor-creditor, but I'm asking you under trust, and we're not communicating.
Okay.
The interest that you got back is really the payment. What is the payment? I really want to know what is your interest according to trust, not debtor-creditor.
What is my interest according to trust?
Yes.
My interest is the trust res.
No, it's not.
No?
Your interest in this case would be the payment you were supposed to get back.
Yeah, absolutely. That's right. So is the payment the res?
No, you made the special deposit with the res, and then the res was generating interest, and the interest you were supposed to get back was your payments in return for the special deposit, which was the intellectual property, all held in trust.
And the res was the original agreement.
The res was the original agreement between us?
Well, I would say that the res in this case would be your knowledge that you gave them to perform this transfer of their assets, set up their manufacturing and stuff in this other entity. This and the interest generated on that special deposit, that intellectual knowledge, was the payment you were supposed to get back.
I'm sorry, say it again, please?
You were supposed to get paid back, what was it, 5% you said?
Yeah.
Okay, that's your interest on the special deposit.
My interest on the special deposit.
So what are you saying, Jacob? Your original intent.
You better write an indenture stating that you want interest on your special deposit. So let me read something out of the back officer's handbook that I've been reading over and over and over and over and over. Section 19.02. Let me find it here.
So I'm going to make an indenture So you got to have an indenture.
Yeah, an indenture is the intent and purpose of the grantor, and it can be written or can be oral.
That's on page 19, section 19.2?
No, that comes right out of Gilbert's. Page 18 and page 78. Methods of formation of trust on 78 and the elements of a trust on page 18. Now, this is Back Officer's Handbook. This is 19.02, Section 2C, Special Deposits. Special deposits may take a number of forms. Sometimes they are means of holding funds in litigation, trust funds, and cash securities of various types, such as deposits to show good faith in the case of contracts and the like. Attorneys maintain such accounts to hold funds of clients for whom they are fiduciaries. Special deposits are created by special contract between the bank and the depositor. In most instances of special deposits for the benefit of a third person, the bank becomes a trustee of the deposit for the benefit of the... Special deposits are often payable upon demand, sometimes upon terms, and occasionally they bear small amounts of interest, but you could take out the word small. And in many instances, such accounts are evidenced by certificates of deposits. Now, right under that in D, talks about certificates of deposits. Certificates of deposits, or CDs, are instruments used by the bank specifically that a certain sum of money has been deposited. And these certificates may be either negotiable, that's public, or non-negotiable, that's private. When non-negotiable or private, the bank simply contracts to return the amount to the depositor. That's non-commingled. That's segregated funds. Plus any contracted for interest again. Interest. If the certificate is negotiable, the bank agrees to pay the depositor or any person whom the depositor shall order or the bearer of the certificate. And when the CD is negotiable CD, the debt of the bank is the legal holder of the certificate and not to the original depositor. But both of those mention interest. If you want interest, you've got to specify it in your indenture that my deposit, my special deposit, was supposed to bear interest.
Go get him, Jacob.
Okay, now in section 3 there, it says opening an account. Opening an account in a bank involves only a simple contract in which the depositor lends money to the bank. So who's the lender here? In return for an agreement by the bank to pay back the amount either with or without interest.
So my 5% is the interest on the special deposit.
Yes. But it better be an indenture.
Yeah,
It better
an indenture.
be in purpose of the grantor.
In purpose of the grantor.
Mm-hmm.
When you make up an indenture after the fact and you have it notarized and the date of your signature you put as of
Can't be after the fact.
Huh?
Can't be after the fact.
The notary can't be after the fact?
No, you can't make up an indenture after the fact. It's got to be a present transfer representing grantor's intent and purpose at the time.
Oh, it has to be a present transfer.
Yes, now that present transfer may have happened 3 years prior, but you better have an indenture or an oral indenture representing the intent and purpose of the grantor at that time.
Okay.
Or else you don't have the 4 elements necessary for the formation of a trust, which number 1 is intent, number 2 is purpose, number 3 is parties, and number 4 is specific trust res.
Okay.
with the records approving that, and along with, that's on page 18, and along with on page 78, the method of formation of a trust, say like what we're using, transfer, which is number 2. Now you got a trust. But now an indenture, which we were talking about a couple weeks ago, is as simple as, hey, I want my pen back. That was an indenture. That was an instruction for you to keep my pen segregated so I could get my exact specific pen back. And if you didn't give me my specific pen back, you didn't segregate it, you breached the trust. But the fact that I said my pen back, that was a segregation preposition. That set up a trust.
I'm asking for my interest back?
No, not my interest, my special deposit. My
special deposit.
So now, how would you make up some kind of wording to apply it to some of the things that we're thinking about doing, that you've got precatory language in there, but yet you don't use a lot of trust terms and give the ball of wax away, what you're doing?
I see.
So it's as simple as this. I direct you to separate my original records or my original property for future return.
I direct you to separate
my property from me unless you keep it separate.
Wait, I direct you to separate my property.
I direct you to separate my property for future return.
Future return.
In other words, I want my special deposit back. The same thing I gave you back. I want my pen back. I want my specific trust res back. That was an indenture. That set up a trust.
Oh, so he basically can't do that, right?
If he doesn't give me my special deposit back, now he's breached the trust. So if my intellectual property did not bear fruit and get returned to me, then it's a breach of trust. If my special deposit did not bear interest and get returned to me, then it's a breach of trust. It's a breach of the indenture.
Well, Christian, isn't that what the banks are doing to us constantly with their the demand? Huh?
Welcome to trust law.
Yeah, because what they're doing is they're taking our notes and they're not producing anything in exchange for it. Then they're taking our deposit.
We're not expressing a trust and proving a trust. We've created records of debtor-creditor, and all along they knew it was trust. Except you never knew it was trust, and you never expressed it to be trust. You never claimed it to be trust, and you never collected as trust.
Christian, in that case, in a mortgage case, since, like in debtor-creditor, and I guess everybody's just now trying to apply this in a mortgage under trust, they don't, the only thing that they pay attention to, and I'm involved in a lot of groups, and I hear a lot of different ways of doing the debtor-creditor, and I can see how some of the things that they're doing, when you flip them into trust, are good to know and work.
Yeah, but you have to look at it. This is how they've been getting us all along. They've been coming at us as trust under equity, and we were already presumed to be guilty because we weren't making the payments. And they're clobbering us to heck because we don't have the records that we can show that we made a payment. And I don't care what you do, you're not going to be able to unless you have a record that you made a payment.
So,
because you're treating it as trust.
Okay, so
now we reverse it.
The only thing that they have to recognize in a mortgage case by law, I think it's in every state, is they have to offer the people right now they're offering them a way to cure their default, and it's in the
under
form,
debtor creditor.
No, but this is under a loan modification, which is really only, huh?
It's under debtor creditor.
No, I realize. Just let me finish though. But the thing is they have to receive that document. So I made up a new document, and I stripped out all the debtor creditor on a loan modification. I turned a loan modification into a trust. And so I'm going to present that trust document to them, and they're going to have to receive it because by law they have to process it.
Well, the point, it remains to be seen whether or not you have a trust, because the actual proof is it's really the manifested intent of the grantor. You have to have record. That's the manifested intent.
So you can't mention anything until you have records?
And you don't have a trust because you can't prove the trust if you make a claim for trust. That's what I'm teaching everybody. You got to have the records created to be able to prove the trust if you claim a trust. He who claims trust must prove trust. That's an equitable trust maxim.
Well, in this
I got
case,
trust. You got to prove it. Where's your record to prove you got a trust? And that encompasses the elements and the method of formation. If you don't have records of those things, you don't have a trust. You can't prove the trust. If you can't prove the trust, you don't have a trust.
well, in this case,
The records. You got to create the titles to the thing. You got to be able to prove the titles. The only thing they can see in their court is records. The records represent your manifested intent as a trust.
okay, so I'm working on the records for it, but I want to stave them off and buy time to give me time to do that.
Well, now it's like a debt validation thing. Come at them with some kind of
it's a
remedy
debt
on the public
thing.
side. Jam them up with a temporary restraining order or preliminary injunction or something.
But can I do the
Christian,
I didn't hear you.
could you please repeat that? There was too much background.
You need to come up with some kind of colorable way of jamming up the court on the public side, like with the doctrine of unclean hands generated by a validation of debt that they can't answer. Take that unclean hands doctrine under 9-210A4, say. Create the unclean hands doctrine and do an enforcement which generates the estoppel under 9-625, and that's the claim for damages. But under a court of equity, if they're not doing equity themselves, they can't ask equity to do what equity requires themselves to be doing, which is they can't have unclean hands. That alone can get them thrown right out of court on a mortgage foreclosure. But that will also give you grounds to come in and set up a temporary injunction, temporary restraining order, preliminary injunction. Just the fact that you've got a notary certificate which certifies an unclean hands doctrine estoppel, res judicata.
A notary what?
Could you say the process? Could you say that process again slowly on the
Yes.
UCC terms that you just said? You said it so quick I couldn't write it down.
Yeah, you want to do a debt validation according to UCC 9-210A4, which I'm going to put up there. I'm going to say that the debt is zero, and they're going to validate that or say that it's not so, which they never do. And then our UCC terms, that's 14 days they got to do that. I do that by notary presentment. And when they don't answer on the 15th day, after the 14th day, 15th day, now I can have the notary certified a non-response. Now that non-response is the generation of a certificate by the notary that certifies that they now have unclean hands. And by the unclean hands doctrine set up by that 9-210A4, now I can come under an estoppel with that, and I could come in with damages then under 9-625. But that estoppel, that notary certificate of dishonor representing the unclean hands, that alone is enough to get you an ability to come in under a court of equity and get it kicked right out of court, a foreclosure. But that also gives you the ability to come in with a temporary restraining order or preliminary injunction to freeze everything up. That's why I say to get a 9-210A4 going first. That gives you a colorable remedy on the public side to jam everything up. And that's something that they will recognize.
And so on the court procedure side, how does that pan out?
Well, I just gave you about 3 different scenarios which way to go. Under the 9-625, you can come at them with treble damages for the unclean hands breach there. Come in with a temporary restraining order or the preliminary injunction. Or you can come in to court kicked out of court.
The question I asked you a little bit earlier about the dip hearing, could you also do a dip hearing on their private accounting and ledgering books that brings it forward that they never loan any money through the Treasury?
Yeah, but that's too much truth in the public again.
Yeah.
Yeah, you're liable to get shot, Chris.
Yeah, I'd have to bring that in chambers, but I'd bring it in under trust.
Yeah.
I like the power of the trust is exactly, you're using the opposite of what they're getting you with, and you're using it against them, because the court of equity is going to assume that the trustee is guilty and can't prove himself innocent unless he's got a record of a payment or a distribution. He's guilty already. That's it.
Christian, are you going to post this recording when you get done tonight?
Yeah, I'm going to try to get it up there tonight,
If you can, I'll go over this a half a dozen times, and won't try to bug you anymore.
Well, I've gone over this many times in the past recordings, too, also. I don't know exactly which ones, but, we've gone into depth on this many, many times.
I know, but I listen to so many of those recordings, tons of them, and I keep listening to them, and I will continue to listen to tons of them. But there's nothing that shows you what's in each one of them to, help you find what you need when your mind is focused on it, at least mine.
Yeah, I know. They're not indexed, so that's a problem.
Yeah, if you need help, I'll try to help index them, because I'm going through all of them 18 hours a day, every single day.
I'm also recording this too, Jacob, if you want a copy at the end of the call.
Okay, thank you.
Yeah, I'll have to be leaving at 9 o'clock myself, so I'll have to end my part of the call at 9 o'clock. But, yeah, if you want that recording, I'll send it to you through Skype.
Go ahead and put it in our Skype box, please.
Yes, sir. Anything else?
That's it, sir.
It sounds like, Jacob, you're starting to understand this. It takes time.
I'm really worried. Tomorrow I have a huge meeting. It's huge. I'm taking on a huge responsibility for over 1,000 families who have been foreclosed on that are Hispanic. I actually got the money to buy their homes and give them to them, and give them new loans so that they can all save their children and stay in their houses. I don't have time to do it in any other way except for by private banking. So I'm trying to think how I'm going to control a ton of different parties in a trust, because these guys are all, in a contract state of mind, state of being.
Yeah, they're all under debtor-creditor mentality.
Yeah, they're all got their attorneys there. They're all when you get in a big deal, this is something I didn't really go after. It just fell into my lap, and I saw an opportunity of, a 50-50 chance of helping some families so they don't go out into the street. And so I thought I would do it, and so now it's coming down to the wire, and
But that's the real beauty of trust, because no party in the trust needs to know that a trust is being formed. That's the grantor, trustee, or beneficiary.
Yeah, well, that's what I'm going to try to do. I'm going to take one party that has the homes, and I'm going to take another party that has the money, and I'm going to take another party that is an insider at the banks that actually can buy notes at heavy discount.
No, there's an easier way.
Is there?
Yeah. You already have a trust. If there's a note, there's a trust.
Yeah.
But the bad statutes in that bankruptcy case, I forget what it was, in re something, I forget what it was. But anyway, that bankruptcy judge, he said the signer on the note is the trustor. And the trustor is the same as the grantor. Those are trust terms.
Yes.
That note represents a trust.
Oh, but you got 1,000 of them.
You already had a mortgage. You already got a note. That note is a trust. Now, start treating it as a special deposit and call it back. Order it back. Order them to surrender the note. You already got a trust. You're just not enforcing it.
You mean instead of using money to pay for them?
Huh?
Okay,
It's already been paid for, Jacob. All you have to do is force them to present it.
Yeah.
And then once they don't present it, then they're in breach of trust. They have unclean hands. And the whole thing is closed out.
What's the particular wording you would put on that, Christian, in order to order back that instrument?
I would order the return or order the surrender of the note.
So, Christian, when you have 1,000, and it's literally going to be thousands, by the way, so I have like a list of notes of all these families, and I have like Bank of America where I have like 300 notes. And so then I have, IndyMac, and then I have Wells Fargo, and then I have Chase.
You got 300 trusts. You see, you're not thinking trust.
I'm trying.
Yeah.
Believe me, I'm working day and night at it. I'll keep trying. Okay, so I have 300 trusts.
So each one of those trusts, you have to demand the note back. And once they can't produce it, then you've got them in a hangsman noose.
Yeah, as trust.
Well, you guys know what happened today in the banking industry, don't you? Something went down today. I got a call this morning out of Europe, and something happened today. Did the LIBOR rate reset today? I think it did.
I don't know what the British did.
Well, that's the that standard they're using for the adjustable rate mortgage interest. And so in California, I know today they blocked the notes for certain values today. So they took notes that are for $250,000. If it's $250,000 or less, you get an automatic 20% off of that as of today. And then if it's 250 to 750, you get a different rate. And then if it's 750 on up, you get a different rate. All these poor families all fall below the 250.
Yeah, but you see that block term is a portal term again. Most of these terms are all portal terms. Whether or not you want to understand it as debt or credit, or whether you want to understand it under trust.
I do want to understand
Instead of it under debt or credit, it was blocked as a discount, say, because it's now worth less under debt or creditor. But blocked under trust means that it was specifically earmarked for a tranche or a transaction.
Okay, I guess that sounds about right.
So there's guys in it to be, hey, you guys don't have anything under debt or credit. We got to devaluate this, but under trust, they're doing something different with it. everybody's getting smoked.
Is there a way to do a cookie cutter thing where you could do 300 of these at once?
No, I don't think so. You have to probably do each one separately because each one's a separate trust.
I mean, if you had 300 at Bank of America.
Well, you might be able to do it that way. But you'd have to treat them each individually, separately somehow. But, they're all going to Bank of America.
Well, maybe what you can do is have a one letter, a validation of debt, and you put all the account numbers down or the trust numbers down, and they have to respond to all of them.
Yeah,
and so the phone numbers are trust numbers?
To where we are, in understanding, because, we're only as strong as our weakest link. But, there's some basic understanding you need to get under your belt, as quick as you can and get up to speed.
Tell me how to do it, please, and I will.
Well...
Study.
Yeah, that's
the
problem. Yeah.
But how do you study to get the basics, under your belt, and where?
Gilbert's.
I've got a short list out of Gilbert's. I'll give you that. That kind of gives you some shortcuts, but let's see. Okay, it starts out on page 6. That explains section C, which is relationships. So these are the whole key points out of Gilbert's. And then you got page 18, which is under section A, which is elements of the trust. That's an important one there.
That's elements.
You can't form a trust unless you got that one down. Then you got page
Hey, Christian,
28.
can I shorten this for you?
Yeah, it's a short list, yeah.
No, I said, Christian, can I shorten this whole thing for you?
Okay. How do you do that? Go ahead.
Well, I created a document called the Trust Outline with all these elements in it. And Jacob, if you'll Skype me, I'll send that to you.
Okay, thank you. I probably won't sleep tonight. That's good.
All right, you can Skype me at Imagine the One.
At what?
Imagine the One. It's the numerical number 1, and I'll send it right to you.
Okay, Imagine the One?
Yeah.
Like IMAGINETHE, the number 1?
Correct.
Okay, thank you.
That's generous, Eric. I appreciate that. My answer is going to be a little more flippant, which is to go back from November 1 and take about 150 hours of listening time and start from the beginning. But that was just my
do that
answer.
Too.
Well, I think that if somebody's going to take the time to do that, it'd be wonderful if they had something in writing they can go by that has some good stuff. Hey, I'd like to jump in, and one thing that I've been thinking about recently that I think we should all try to wrap our minds around more and more is just the concept of special deposit and how many different forms that can take, because obviously that is when the trust is formed. At that moment, that creates a present transfer. So maybe if we could even talk about a few different scenarios that we might be able to understand. Maybe you've got some ideas on that, Christian. That'd probably just clear a whole lot of things up for a whole lot of people.
So what you're saying is the special deposit actually is the strike point of where the trust actually becomes a trust.
Yes. Right.
Christian, is there anybody you know that could help me with that project I've got? To help both.
Nobody knows this trust stuff as far as I know. I'm the only one that's looking at it this way.
Can you help?
I know you're going to ask that next. I can't help specifically everybody, all at once like that.
What about if you could get, a good contribution? To get your whole thing going.
It's easier to talk to God than it is Christian at times.
Yeah, that takes away from, I've got so much stuff going on now that I can't handle anymore, really.
Christian, all you got to do is help me with one, and I'll duplicate it.
I help you on these calls. Yeah, I'm helping everybody.
That's true. So has anybody done this with mortgage yet?
We got some people that are in the process of doing it, yes.
Can you ask them if I could? I'll pay them handsomely. Extremely handsomely.
All right, let me see what I can do.
It's coming down fast.
Christian, that going back to Eric's question. You talk about creating the res and the special deposit. We've talked in the past before about an intermediate presentment. So you could take your the monthly statement that you're getting from the mortgage company that maybe has no numbers or signatures, but it's looking for both. You could do your initial promissory note. You could do that with a credit card as an intermediate presentment. Maybe even the original signature or a copy of the original signature that you applied with.
Right. Just it just gets down to thinking about how you want to apply it and running it through with a group of people and kicking stuff around.
The only thing I haven't arrived at for sure is when you have, say, for example, an intermediate presentment from an agency that is seeking money and they've assessed you with some alleged liability. You can turn that into a special deposit, but when you do that, that might just be, well, I'm not sure if you could set off all of your debts with that, because the moment that you turn that into a trust res, could they not create more alleged violations? Like, for example, they could open up an indictment, and that indictment would represent a whole nother trust that you'd have to turn into a special trust deposit, and then return to them. So it wouldn't be necessarily a one-shot deal if you're facing civil or criminal matters. If it's simply a mortgage, it probably is a one-shot deal. But if it's not, then you're going to have to probably continue to create special trust deposits and form that record. Would that make sense?
Yeah, but maybe even before that, have you thought about just the different scenarios of the parties? Do I want to be trustee? Do I want to be beneficiary first? Do I understand the ramifications of being one or the other, or the advantages of being one or the other? I gave you an example, a while back on, the three positions, like, maybe I want to be grantor and beneficiary, or maybe I want to be grantor and trustee, or maybe we want to have three parties all separate. Like, those are the three scenarios of the three parties. I can have a separate grantor, a separate trustee, a separate beneficiary. Or I can be grantor and beneficiary on one trust and a trustee on another. Or a trustee also on that one, I mean. Or I can be grantor and trustee on another one, example, and a separate beneficiary. So there's like the three scenarios of the three parties in the positions of the trust. And I think that's first going to have to nail down which party do you want to play with. Do you want to be grantor and beneficiary? Do you want to be grantor and trustee? Or you just want to be grantor?
If you're three parties in an original mortgage and you want to become a trustee or co-trustee because the co-trustee has failed at his fiduciary duty, is that possible?
Yeah, that's possible. But then
that's what I see myself in these cases as doing.
In a mortgage situation, I might not want to be trustee because maybe I want to terminate this trust. And I want the bank to be trustee because the bank is already beneficiary.
So they can be beneficiary and trustee then?
Yeah, they can, but that terminates trust.
Because no single entity in the trust. I want to terminate each one of these trusts, right?
I didn't hear you. What?
I want to terminate each one of these trusts as the trust res.
Not necessarily. No, I may want to operate the trust or make it into a monthly billing cycle that I pay or just distribute the funds to. In effect, keeping the trust open, the electric service, but yet want to close it out on a month-to-month basis or make a payment or a distribution on month-to-month.
Can I interject something?
Yeah, go ahead.
Yeah, every bank has a trust company, so the trust company could be the trustee, and the bank be the beneficiary, and the you as a grantor could also be a co-beneficiary, and separate those the trust, the bank trust company, and the bank as two different entities, as they really are.
That's the whole point, to set up the scenario how you want it to play out. But then how you want to play it out, it comes with the understanding of what you know about the parties and what the parties can do.
I believe they can do that.
That's even before we even get to talking about specific trust res. How we want to treat trust res.
Every account and every court case, every mortgage, every one of those is a trust, and every one of those should have its own one and its own three, right?
Yeah, but in that scenario, I'm governed to what the parties are already been established, because it's already set up that the beneficiary is already the bank, and I'm already the grantor, and there's a separate trustee. So we have a set scenario there. So now we could talk in that situation how we want to do specific trust res. But although we're kind of limited on that one also, because we're limited to specific trust res already, because it's already the note.
Mm-hmm. I'm just trying to I'll mute out.
But the notes, unfortunately, are not attached to the mortgage, to the deeds of trust, because the notes are securitized and floating out there, right?
Yeah, that's debtor-creditor again. That's not trust.
Okay, so in trust, when they separate those the security instrument from the promissory note, how, when you treat the trust res, the note is the trust res. What is the deed of trust? If it's separated, then they're actually going to destroy it because it's the evidence of their crime. So you're never going to see it.
Well, the deed of trust is representing the obligation that they're getting you under debtor-creditor.
Okay. So what do you do with the deed of trust? Make it part of the trust res also?
No, I want to think trust, and I want to think trust deposits. And I want to think, after I made a trust deposit, that was a payment when I merged the titles, and that became a trust receipt. And trust receipt is a record of a payment. And Black's Law definition, 8th edition, says that the trust receipt is a pre-UCC security device, now governed by Article 9 of the Code, consisting of a receipt stating that the wholesale buyer has possession of the goods for the benefit of the financier. And today there must usually be a security agreement, now that's your indenture, coupled with a filed financing statement, now that's your UCC 1s and 3s. Now they're talking about that's a trust receipt? A UCC 1 and a 3 in my indenture? A security agreement? And a receipt is what? A record of a payment? Well,
where's that from?
Under trust.
Well, where's that
What do you need to worry about a security for and under a debtor-creditor? And worried about the segregation of the whole thing.
Well, they've segregated splitting the note and the deed, right?
Yeah, but if they segregated under 9 what is the number? Forgot the number. 9-633? What is it? I forget which one. The commingling.
Oh, that's 339.
Christian, 9-336.
339? Is that what it is?
9-336, Christian.
Okay, there you go. 9-336.
Okay, the commingling.
That's commingling.
The note
they commingled Under debtor creditor, that's 9-336. They commingled under debtor creditor, but that is also under trust. If they commingled, they breached the trust.
Okay, and so does that breach become the trust res, or you still have the notice to trust res?
No, that doesn't become the trust res. That's the breach of the trust res. That was the breach of the
breach of the trust res, okay.
And Christian, in the event that they breach, then that's where we can utilize the equity court to compel action against the trustees for failing to make the payment, correct?
Yes, once we've claimed trust and proved trust and made a prima facie case by the beneficiary. And then when we had our protective order, and brought it into court properly and asked for the in-chambers camera hearing. Got to get in the court of equity and on the in-chambers private side. In order, that's where we're going to find our real substantive man, pre-1933 equity. Not this
statute. Well, in this situation, you'd have, a number of families gang together under one bank. Let's say it was B of A, so it would be easier to treat that as one case.
A class action suit, I suppose, but yeah.
Yeah, it's kind of a class action antitrust deal because they really picked on these Hispanics heavily.
Well, I think you should get maybe one small one under your belt first, and then try it in a more bigger way.
Yeah. Okay.
Can you think? What were you reading that from?
Which part? I don't. 9-36.
Pardon me?
9-336. That was commingling under UCC.
That was the one that you were reading that from?
I wasn't reading anything.
Well, top of your head then. Oh, okay.
Yeah.
Before that.
What was it in reference to, Frank?
Well, this topic we're on here.
This is kind of encompassing everything, really.
Yep.
Eric, did you have a question? You said.
No, I'm just listening. Well, I think we kind of got danced around the whole idea of just talking about different scenarios of special deposits. So we all can have a nice discussion about at what point our trusts in different scenarios actually form, whether it be a court case or a mortgage situation or a situation where somebody might be entering into a business agreement. Just a discussion about special deposits so everybody really knows where this thing actually takes off from.
What we might want to do is we might want to split, say, like this trustee ambassador call up into two segments. We want the way I see it is we have a lot of beginners on here and we have some more people that are more advanced. And each one of you have specific questions geared to your own degree of knowledge that you understand. And the questions are, we don't want to repeat the same questions that some of the more advanced people already know and understand. So maybe we'll split the call up into two segments to where we got like a beginners and a more advanced one, something like that. And maybe if you'd send me some topics that we want to discuss, maybe for the more advanced people, we want to talk about specific trust res because they already know about parties and the other stuff and records of formation and the trust and that. So maybe I should send me some information on some guidelines for some topic guidelines that I can maybe direct the call in a specific way so that it benefits all of us to a better degree rather than taking up all our time on this call to talk about some beginning stuff, which is, hey, it's great, but trouble is you're slowing down the rest of us all in I can't help it that, these people on the call now more advanced have spent the time in there, and, it'd be more deserving to, bring them along fast as well as everybody else, but, I can't split and please everybody at the same time. So if we could maybe direct me some input from that, specific topics which you'd like to go through, but I'm sure that, that the information we've already talked about before, and it's already on the call, and I really don't see a whole lot of need to going over it, and we seem to be hammering the same thing over and over again for every new person that comes on, and really that's not great for the people who want to go a little farther and faster, and that's the whole purpose of this call, because this is the more advanced call.
Yeah, Chris, I thought the whole idea of the call was the 12 or 18 trust ambassadors, if they wanted to have some of their team sit with them, but it was going to be the people that were invited on the call. So, and I thought those people were supposed to be
the whole purpose of the call set up that way.
Right.
And I would like to see it get back to a more structured thing and maintain that structure, because we have plenty of other call time maybe for maybe some of the basic more stuff on some other calls.
Well, that goes back to you assigning who the ambassadors are, and only ambassadors are allowed on the call.
Yeah.
I hope I'm an ambassador.
Yeah. Right, you have a Tuesday, a Wednesday, a Saturday call. There's another 9 or 12 hours of opportunity for anyone else to come in and ask questions or listen, or go back to the other 150 hours of tapes. I was talking with Eric about this earlier. This may be, I don't know if it may not be selfish, but in the interest of keeping communication open too, I know this call is recorded, but we might want to also consider the idea of the Trust Ambassador call not being recorded, because as I understood it, it was in part going to be more of a think tank of people trying to bring docs forward and move things, get maybe some higher level of clarity, and that might, if the Trust Ambassadors decide to record it, but not necessarily making, the call always posted. That's something else to think about, but sometimes that frees up people to talk. I know there's often the same people talking on the Monday night calls, and it's not a ton of people anyway, so.
Right.
Well, guys, I'm sorry if you thought my question was good. I just thought if we could have a good discussion going about that instead of anybody just have an idea maybe in present, and then if we go back to kind of have a
Doug and Pete and I and Eric, we've been passing around and drafting certain types of documents, and it's a good learning process. We're all, I think, moving down the path and getting a deeper understanding of how we do some of those pieces and from a higher level. But I'm conflicted on some of those pieces, because as much as time as we're spending doing that and learning in the process, and it's always good to do it for yourself for the first time so you can stand on your documents. If you have a bunch of those in place, we're reinventing, like on a different island, essentially, the same types of documents. And it seems like we might be able to collaborate and make the documents better faster, rather than starting with some of those from ground forth or ground up. So my question is your arsenal of documents fairly well put in place, or is that something that we are all going to collaboratively do on the first set of the first seminar, the first go around? Would that be the time that we create the documents from first impression?
Yeah, because really there is no documentation that really exists.
Okay.
We're creating it.
When do you start the workshop?
Shortly. Let's put it that way. I can't exactly say when. I got a few other things I got to accomplish yet.
Well, Kirsten, you answered my question then. So, the documents that we can bring to the table for review, it's not lost work product time. it might be a good starting point.
Yeah, right.
Well, then I'll email you at least what has been put together from, the 3 or 4 different standpoints, different types of documents, and you can archive those if that helps springboard the process then. In the beginning of the seminar, then even better.
Yeah, we might want to revamp the Trust Ambassador call here to, like you said, maybe a more private thing, maybe the more document sharing, and hold it more towards more of the advanced stuff that we're working on. Because I noticed we've gotten off track. I mean, I haven't had a chance to study the Practical Treatise on Law and Trust, and that was really supposed to be the focus and takeoff point from it, and we haven't really talked about that. We're kind of falling behind on that for the last month, but I mean, I see a lot of good stuff in that. But there's only so many hours in a day.
Philosophically, you're going to open up your seminar, your workshops rather, and whenever that happens, and the second time you have a workshop, the documents will have been created, and I hate to use the word template, but essentially there'll be templates on which people can start to create their own documents. People are going to go through this 20-hour workshop, and you'll have people in there who are just beginning. They don't have 120 hours of listening and digesting and all the rest. So they're going to start, and as anybody else has started in a workshop, they're going to want their documents. They're going to study and prep them. And of course, the real test is when they have to stand on them in court, and that's going to be in private chambers. That's where they might have to continue to study. But I also think that just getting that document prep done, understanding what it is, why you're doing it, once you have those templates set in place, I think that'll give people a good 80 or 85% understanding of what they need to know, and then the other 15% will come with the off-site study, either during or after the workshop, as they're doing their process, and as they become a believer in what they're doing and how they stand on their paperwork. So I guess I also encourage that. I think once we draft some of these documents and put them together and collaboratively create them, we're still going to have people that are going to view that as templates and, have to help them along anyway.
Yeah, but the ultimate responsibility rests with them, because they're the ones who are going to have to. They're going to have to present the documents and defend them.
Right.
Well,
has anybody made up a debt validation trust document?
Yeah, those are out there. That's not a problem. If you go up on Skype right now, I'll go ahead and send you some that I have.
Okay. My Skype thing is j.evek. E-V-E-K. It's St. Petersburg, Russia.
Okay, anybody else have comments or something?
Well, my thoughts on the ambassador thing, I think our main objective is getting into the main account, because everyone else it seems to me, has their separate issues. But the main one, getting the launchment made and the Declaration of Independence and all that paperwork for the DIB, and it's all going to apply to their individuals once they get into their DIB account. I think that's what the main thrust should be right now. That's my personal opinion. Not dealing with these other issues, because it all stems getting into the main account. And I really enjoy going over all this stuff, but the main thing is getting into that main account and getting that paperwork down.
I second that.
I want to add something to that, but it's not only that's. I think even beyond that is knowing who we are as sentient. Because until we know that, then we could be knocked right off of it because we're gonna commingle again.
Yeah, that Tuesday night last week really struck a chord with you, Eric, didn't it?
Absolutely. They pull you over, but a cop pulls you over and he starts giving you a hard time. If you don't know who you are, they're going to bury you in a second.
Did you go over that? I didn't have that. I think it was February the 7th. That's the one I talked about sent here on there. I just put it up about 5 days ago. Did you get a chance to listen to that again?
I probably have. I record most of the calls that I get the chance to come on to. And if it's been since February the 7th, I've probably been thinking about it since then, but then you hear the word again, and then it just resonates further and further.
I had posted it up on the website about 5 days ago, so it wasn't up there. So unless you had a recording yourself, but it's up there now.
I probably did.
And I have it listed on the title there, sent here. That's the one I did a pretty good in-depth discussion on sent here and intent and purpose of the grantor. And really, the knowledge and understanding is really the censure. And if you don't have the knowledge or understanding, you're really the fiction. Because that's the way you're acting. And
for that reason, why should the outlaw court look at anything but your title?
Yes, because your action's going to overlay your actual paperwork and stuff. Your actions speak louder than your words.
Right. So going right back to the gentleman speaking just a moment ago about getting access to the account, I really feel like if we don't understand who we really are, we don't deserve access to the account.
Well, we may gain access, and then we turn around, trip up, and end up commingling and lose it all again.
Well, I understand what you're saying, and my name is Michael.
Hey, Michael.
And I guess I'm assuming that other people are aware who they are. My standpoint is I understand who I am. So I guess, like CW said, if I do screw up or anyone else screws up, we just mess up our own account and hurt ourselves.
And that's one of the concerns I have is, for us that are going to go through the first workshop, and then for the people that are going to jump on board and just plug right in from being told on this on the second one and then use the templates, there's going to be some of the people that are going to be successful, but then there are going to be some people that are going to hit the wall on that, and they're going to wonder why, and it's because they don't really understand. With this great resource comes great reason to have the understanding of it and responsibility of it as well too, because you can't just go out and give just anybody $10 million. They're going to be dead in 6 months, or it's going to be gone. So I really think that's a big part of it.
Yeah, it comes with the understanding and knowing how to administer the trust, which is what we're starting to do.
And that's really,
and I call out of the good.
And that's really what I was getting at. I'm sorry. Go ahead.
No, go ahead. Finish.
And that's really what I was getting at about the discussion with special deposit, because if we don't really understand what special deposit really is in different contexts, then how are we going to ever understand how we do that as sentient?
Well, we can reserve the main.
If you don't even know when it's occurring.
Well, we can reserve the main trust to study on the main trust for a separate people. But who's the one that's going to judge who's capable of getting into their main trust or not?
Right.
Well, we are when we correct our IMF. But my point on that is, even if we happen to get successful in correcting the IMF and getting access to the account, if we don't really understand who we are as a non-resident alien and against a fictional corporation and how to conduct ourselves, then how long is this really going to be how long is it going to last, or is it just going to be something that's going to be here and gone? And are we going to ever really succeed in taking our republic back?
Well, I think if I may, what Michael was referring to is, go ahead, Christian. I'm sorry.
It's just like what Franklin said when he was asked the question, sir, what have you given us? And he said, a republic, if you can keep it. Go ahead, Casey.
That's really what I'm looking at the big picture here. If we're just going to dilly-dally with this, I don't know. I don't think it's appropriate for any of us to get involved in it. But if we're really going to dedicate ourselves, then we need to understand what it is we're getting involved in. And it's not just because we have, one small mortgage or one credit card or one little issue, but it's really about the future of our country and those that we love and care about.
Hello.
I'm still here. Christian? Anybody else there?
Yeah. Right here. You might disconnect and reconnect. Well, Michael, I'm with you. You said you referenced getting access to the account, and that's just simply a measure of your success of claiming and correcting your IMF. Nothing more, nothing less. Whatever you do with the funds, however you commingle at that point forward, to me that's irrelevant. Because philosophically, this is about, we know who we are. Everyone on this call probably does or should know who they are. Going and correcting your IMF record and getting that cleared up so that you even have a prayer of then getting your W-8BEN modified form submitted so that then you can stand on that. That's a whole other issue. Getting access to your private units, that's another issue. This is all about correcting the IMF record so all those comport to it, and that starts with the step one. That starts with stopping the prescription and going forward from there. However we do that, and there's 5, 6, 8 documents that we need that to prepare, get those submitted, get a 120-day clock going, and we're working on those. I'm patiently waiting for the seminar to start so we can start that process, and we'll do that in the first round. And the first group will get their docs submitted, and the second group there'll be 150 people behind that first group that don't really know what they're doing. They're just sort of relying on the templates that were produced from the first group, and the first group's documents will probably be refined and made better, but most people, they probably won't really be able to stand their documents anyway, So, but that's you can't. And I think, Michael, you alluded to this. It's not ours to screen out those people or even judge whether they should start the process or not. The fact is, we're all here moving forward, and we should move forward with full speed to get our documents in place, because I think time is of the essence in everything that we do.
Before they extinguish the prescription force.
Who knows what happens? We're talking today freely about whatever we're doing. Who knows what happens tomorrow?
Well, the thing is, this is what.
This is what days from now.
Yeah, this is what Terry and I have been looking at for a long time, and we agree with CW. It is everything's in the trust, and it's just being able to move everything and get everything in the right order. I don't know where the rest of you come from as far as the debt of creditor, but Terry and I's background is deep into Scripture, and some of you have heard some of the things I've said, and I've tried to keep it low profile because I don't want to preach to anyone. Every man has to study to show himself approved, but this whole thing it's greater than we are. And if we do this right, it will change the planet.
Michael, I appreciate that. I told Eric and I were talking earlier today, and I said, what? I feel like in the group that we put together, the documents that we put together, we could probably start to submit documents today to several of the respective agencies, and based on what we've studied, based on what we know today. They might not be perfect. We might modify the documents later on, the forms and such. But I'm holding off on that, and as are other people, waiting for that first workshop so that we don't submit anything with even minor errors, let alone gross errors, so that, say, for example, if you submit something to one agency and they sort of understand what now is trying to happen, and that becomes an impediment and a roadblock to the other people coming behind us. So out of a responsibility to those that will follow, I'm trying to make sure that nothing gets submitted until we have that pretty well under our control.
Yeah, we've all been through the debit creditor thing and doing all this other stuff, and we saw how it was done gun-ho and not thought out. And some people got a remedy, but majority of them, like CW said, didn't. And I agree with you. You know, they will put up their walls if we do it wrong. And we got to get in there quick, and if we do it right the first time, it will give access to other people. The most telling issue, for example, I mean, everybody has a Secretary of State probably that they try to take documents down and get apostilled. And the Secretary of State says, no, we don't do those anymore, or we're not going to do them for you in those documents. Well, I don't want to see 30 or 40 people because they've sit on one call send a DUI within a lawns to the Secretary of State, and all of a sudden, you know, that 31st one in their forward, that department sends it back saying, yeah, we don't do these anymore. We don't apostille these types of documents. We're not going to do it for you. And that's one more piece of the evidence that we need for our law form to take in and claim that that's what we stand on. So again, it's just, well, it's just
they can.
It's just like the founding.
That brings up a very interesting point, because wherever we do this kind of thing, maybe we need to come up with Plan B and C for other apostilles and whatever else we need to do before if people were to get refused.
Yeah, we might have to. Or in that first workshop, we might have to just figure out how to, you know, who knows what that's going to look like, but it's not a bad idea. Go ahead, Michael. I'm sorry. Michael, you had some thoughts?
Is CW on the call?
He said he was talking like he got booted off. He'll rejoin when he does, I suppose.
Michael?
Yes.
Did you get that JV thing okay?
No, just send it to, send me your Skype name. It's Michael613.
Okay, Michael?
Yeah. Just ask me to, ask to be added, and then I'll be able to send the stuff to you.
Okay.
Sorry about that.
No problem. I'm going to do it.
Michael, you and Terry and... I'm sorry. Go ahead, guys. Michael, you and Terry in Louisiana close?
We're very, very close. We don't live in the same state, but we're very close. We communicate every day.
Okay, good.
There's two of them, Michael.
Which one? Read both of them and let me know.
Okay. I just sent you one. Did you get it?
Yeah, I got it.
Okay, that was the right one then. I won't waste your time.
I'll go ahead and add you and then send it to you.
Michael, my background is in...
I know your background. We've spoken before. You're very, very knowledgeable.
Yeah, I'm really not like you guys. I mean, I'm not into the court thing. I never have been. But I think I'm really getting a revelation here. I think there's something, and I like the fact that you and Terry are well read in so-called scripture. But because before I don't know, I'm getting this premonitions, by the way, about this area of truth that we're all working in, and I was just thinking, can you imagine if one of the prophets walked into the courtroom? What law form would he put himself under?
The only law he knows.
Very interesting question.
The only law he knows.
Right. So I'm just wondering if I get that equity is the highest form in court of law, and I get that trust law is inequity, but and I heard Christian, he said tonight, how trust was given to Adam, But trust law wasn't given to Adam, just trust. So I'm just trying to figure out where in between there lies some kind of revelation.
Let me share something with you, Jacob. One of the other words for, and the legal definition of the word equity is fairness.
Yes.
Okay? So if you just take the word...
But it's also natural law. Equity law is also natural law.
Which
Michael? Hello?
Hello?
You still with me?
I got you.
Hey, JC. I'm just listening to the call there. The thing is, with equity, it doesn't need explaining. People know how to operate between themselves. They know the difference between what's right and wrong. And that's equity. It's just what's equal. Every man's created equal. And that's equity. All the fiction does is it places a man in such position to operate a fictional entity. And when you're doing a trustee appointment, say, you've given that man an opportunity to pay to his brother and do what he can, which is of equal status. All he's doing is he's acting as the arm for another because he has that capacity. That's all equity is. It's just normal living.
as well as trust. That's why our place is in camera, where our substantive rights are. That's pretty simple.
Even that apart, I mean, you can still stand your ground. It's like saying the prophet walking into the court. He doesn't need to go into chambers and do all that stuff. He knows who he is, and that's displayed by his conduct. And the trustee knows who the trustee is, which is the judge. It should be done without words. It can be done without words because it's about conduct as well. I mean, a young baby doesn't need to learn how to grow up. He just does it. And
so
me,
while we have this precious few minutes... I'm sorry, go ahead, Pete.
No, it's okay. I was just saying that to me is what natural law is, like letting nature flow through you, like.
I was going to say, while we have this precious few minutes to see, maybe if we're lucky, Christian will come back on. Is there anything of a from a conceptual frame that we want to discuss or suggest for tonight or future Mondays?
Special deposits for me is the the big one really now. I think we've covered everything else, and knowing that how to lodge a special deposit, because I seem to remember Christian saying that we could do a copy of rather than give the original, just to tell them that there's one in existence and they're to hold it for us, but you don't necessarily have to give them the instrument.
So what you're saying, Pete, is you can notice them that there is a special deposit being held in the private.
Yeah.
But not actually transfer it.
Well, you've transferred the notice, so he's got his duty that he's to hold it. Because the nature of trusts, remember, is for when the grantor dies. So the trustee's got his duty, the res, he's got a copy of it, which is could be certified. I'm not even sure whether it needs to be certified, but the fact is he's got ownership, legal ownership of the thing when the grantor's indisposed. And that's for named beneficiaries.
and that works perfectly in the scenario. For example, I have a house and I want to give it to my son, and but I'm going to live in the house till the day that I die, and I am not giving up the house until I'm not transferring the house because I'm still maintaining possession of it until a future time. So that's right along the same lines as what you just said, but I could still set up the indentures of the to the trustee that there's a special deposit, but not actually do the transfer of the risk.
Yeah, of course, yeah.
Okay. Well, that brings up a wonderful discussion about all different types of res and transfers, and yeah, I think we could have a really good understanding by having an at-length discussion amongst us about that. If anybody else has anything they want to add in, or if Christian's back on, and I'll chime in. Anybody got any ideas?
Well, the thing that kind of struck us is, because, you know, we work with a group and everything, if we place in a special deposit, then how does it accrue interest? What rate is the interest at? Is it at a shareholder's rate, or is it at the rate of the, you know, what the grantor specifies, or where does the interest rate stem from?
And what is the interest based on our understanding? Because remember, interest is a portal word.
Interest is what, sorry?
A portal word.
Yes.
So we have to really define what interest means in our for our purposes, in our intent.
Yeah, which then we would have to look at accounting and equitable interest as an asset, or as part of an asset to whoever it is that we give the special deposit to.
And then where it becomes really slippery is when, for example, on intellectual property. For example, the stuff that Christian's sharing with us, all this intellectual stuff, and he's creating a trust with us when he shares it all with us. What is the interest in this?
Well, the interest is being generated like now, isn't it? You know, when we talk, so he's actually, you know, that's the interest there, I would say anyway, is that he's getting people to take responsibility for themselves.
Okay. All right.
I mean, that couldn't get much better payment than that, really, as a payback.
So for what it resonates back to him?
Everything.
And then actually the real interest would be the real yield on the investment that he makes is we actually take our republic back.
Well, the republic's there, isn't it? It's whether you want to step into it and acknowledge it and know what it means to be there. You know, it's like saying that you can stop your blood and your heart and your brain working when you can't. But it's been working all along. But, you know, do you acknowledge all the things that's going on?
Okay.
And that's just your body. Never mind the rest of the world.
I guess you could say it's really closer to us than our own skin, but it's whether or not we make a conscious recognition.
Exactly. Bring it all to the conscious.
Okay.
Yeah.
Okay. So, as far as the transfer or the res or the special deposit in a mortgage case, I think we understand what that is pretty well now. That's, for example, our signature. When it comes to a court case, he talks about that it's the case number, and the reason it's the case number is because it encompasses everything within it, correct?
Yep.
Okay. Now we understand that pretty well. Let's talk about other scenarios where a trust might be formed, where there's a special deposit. We talked about intellectual. Anybody else got any kind of scenarios we can bring up for discussion? You can think of it?
I think the car one seems to be getting everyone. Is it the DMV with you guys? Here it's DVLA. We were saying about when you put your application in for your driver's license and you get your driver's license, the application is the trust deposit and the license is the trust receipt.
Okay.
And then I seem to remember Christian saying some time ago, whenever you get a receipt, you should give a receipt in return.
But wait, I got to back up here because I thought that the special deposit is the trust receipt.
No, that's the trust deposit. But the trust receipt...
But didn't he just say... Didn't he say, even on tonight's call, that the trust deposit also is the trust receipt? Did he say that, or am I wrong? I could be.
Oh, that's right.
I mean, I'm not positive on that. I'm asking. I'm bouncing it off of you guys. So.
Yeah, the trust deposit.
Don't disagree with me because you think I'm right. Well, let me grab my law dictionary. Unless you got one handy, Pete, and you want to look up trust receipt and trust deposit and see if they're really one and the same.
I don't believe they are.
Okay.
I know it's in Black's first, isn't it? At least the first one is trust
Grab mine up
deposit.
right back.
You know, all I need to do is go back about an hour and listen to the call again. But the trust receipt is the trust payment.
Okay, so that would be the
res
deposit.
is different from the payment.
And the res is the deposit, isn't it?
Exactly.
Yeah.
Yeah,
Say that again and break that down for us, JC.
You know, I don't want to restate what's been said so well an hour ago. It'd be better to just go back and listen to an hour ago when that was discussed. Or we can talk about it offline.
Well, I got both definitions right here in Black's Fourth. The deposit is where money or property is deposited to be kept intact and not commingled, whether the funds or property of a bank and is to be returned in kind to the depositor devoted to particular purpose or requirement of depositor or payment of particular debts or obligations of depositor, also called special deposit, as we've heard many times before. Trust receipt, document in which is expressed security transaction where under the lender having no prior title in the goods on which the lien is to be given and not having possession, which remains in the borrower, lends his money to the borrower on security of the goods, which the borrower is privileged to sell clear of the lien on agreement to pay all or part of the proceeds of the sale to the lender.
Well, in Black's 6th edition, the trust receipt, it says a pre-UCC security device.
Did you say a pre-UCC security device?
Trust receipt, it says a pre-UCC security device. Now governed by Article 9 of the Code, a receipt stating that the wholesale buyer, and this is what Christian read, I think, has possession
That's right.
for the benefit of financier. Today, there usually must be a security agreement coupled with the filing of a financing statement. Method of financing commercial transaction by means of which title passes directly from the manufacturer or seller to banker or lender who as owner delivers goods to dealer in whose behalf he is acting secondarily and to whom title goes ultimately when primary right of banker or lender has been satisfied.
So the two important pieces of that were the security agreement and the UCC financing statement.
said it's a pre-UCC.
Security agreement.
Right.
It says
Right.
It was.
Which is your trust indenture.
Doesn't it say it was a pre-UCC, but now it's not?
Jacob, did it say it is a pre-UCC?
It says it like this. It says a pre-CC security device.
That's what Christian wrote too.
Right. So anyway, what you were saying, JC, is the two key elements there?
Yeah, again, this is one of the non-values of the recording of this call because we're going to rehash this twice, and it was stated an hour ago. Clearly, Christian went through that, and I don't want to.
You guys, you could go over this much time, and you're going to get it. It's going to mean something different every time.
Not really.
Circumstances.
No, the res is the res is the res of the deposit. You have the trust receipt. That's the payment. I mean, it doesn't change. It is what it is.
And that's why Christian talks about giving them a receipt for when they, forward you the receipt back. So you place in the trust deposit, which is the application. They give you whatever the thing is that you're applying for. In this case, it was the driver's license. So you get the driver's license. That's now the trust receipt, and you should give them a receipt back for that, but you never do. And that's kind of the indenture.
The receipt.
Yes, the receipt of the trust receipt.
Jacob, you got the files.
Yes, I did. Thank you.
Remove the name and addresses, please.
Okay.
Christian, a long time ago, talked about the issuance of a certificate of deposit, essentially. So if they're not going to give you one, like in events where they don't give you the driver's license as a trust receipt, you're going to issue them a certificate of deposit anyway.
Yeah.
Again, another issue.
But it's still pertinent to this, because if for example, I went for a mortgage and I applied for a mortgage and they said, we're willing to lend you one. Do you want one? And I said, well, I don't want one now, but I had made the application. Do you know what I mean? And they said, we are willing to lend you one. So the receipt, I've given them the trust deposit, the application. They offered me the receipt, which I declined. So, from what you're saying, JC, I'd say it very much goes with that, because I should really issue them a certificate of deposit.
Exactly.
Yeah.
Because at that point, you lay down the rules.
Yeah, I've made the application.
That certificate of deposit states, though. Yeah, but it's the language of that deposit, what you put on there. And again, it changes. Like, for example, as a driver's license example, you're accepting their receipt. You should give them one as well. We should always give them one. We should always give them a certificate of deposit, no matter we get something back or not.
Yeah, but do you guys actually sign your driver's license when you go in there?
Well, I did, but that was like 25 years ago.
No, I mean, you have to renew it every so often. So, I mean, you can go any time and you can just go in and get a new driver's license, and you really don't have to sign it. I mean, mine is just, I don't have my signature on my driver's license.
Yeah, but they're going to go ahead and contract you by accommodation.
No, because my signature on the driver's license, my name, is all rights reserved. That's how I sign it. Right across the line, all rights reserved. And I go to a very small DMV to do it.
Okay.
Because it's your signature that gets you in trouble.
Your unqualified signature.
Your signature, period. when it says in ancient Hebrew law that you're not supposed to swear, it's talking about your signature. Because when you use your signature and you swear, you bring all the things down here on earth that can harm you. And when you don't do that, then you leave your bond as your word, and you're under the protection from above.
Well, again, you're talking about the unqualified signature, as Eric referenced.
Maybe there's something. Maybe there's something.
If you're signing as a qualified signature, you're always coming in some capacity, some other capacity than you as just a living man.
Yeah, but you think that if some big shot like Moses walked in, he'd walk in with paperwork?
Well, let me know when that happens.
I don't know. The whole idea where you just force yourself to go into court, it seems to me that there's got to be another way to do it.
Well, there is, and that's to be in where your substantive rights are, but you got to play the game to get in there, and you got to do a qualified signature to do that.
Yeah. Who are you going in as? In a trust relationship? That's the key.
Are you asking me or Jacob, Pete?
Well, I'm making a statement more, yeah. Sort of a question statement.
Okay.
But yeah, if you're going in as someone representing a party to the trust, then you've qualified yourself by conduct. But if you don't know that, if you're not aware of that, then you can't prove the trust. But if you can...
Well, once we get into the main trust, who cares if we get a ticket? We just write them a check. Who cares? It doesn't make any difference. The main objective is getting into the main trust. That's my thought
Michael?
on it. Yes. That's my thought on it. I mean, we're spinning wheels. We're spinning wheels here.
Well, that's what I was saying earlier before. That's like under military jurisdiction, because the country that you belong to is held under trade secret. What is it they call it? State secrets, is it? You know, you sign the Secrecy Act or something like that.
Yeah, because see, the bottom line is that you use them as their footstool. They have a system that is going to be here for a very long time. And the thing is, we just have to work within that system. And who cares if they give us tickets or whatever? I don't care. Here, you want your money? Your fake money? Here, I'll write you a check. I don't care. I don't want any. I don't want any.
I'm not going to do that. I'm not going to do that because I want to go in and express my rights and express trust. So after I do that a couple of times, they're going to learn that they're not going to make any money off of me. So why bother? And then they're just going to leave me alone because they're going to know that I know who I am, and that's the real goal here.
What we're looking at is
you got to look at they have many more people than in their army, and they're willing to go through the motions every time. If you want to go through there and go into their court systems, they'll oblige you all you want. Meanwhile, you're wasting your time messing around there instead of just getting rid of the controversy, paying what they want, and get on with your life and doing what you can really do for humanity.
Yeah, we're looking at taking the public law and making the pertinent statutes as our trust res with the state.
Well, the state is going to be here. The state's not going anywhere. It's going to be here, and anyone that thinks that they're going to change the system. I know a great couple of movies, The Wizard of Oz, a lot of movies out there that you can relate yourself to. We have to work within the system. Let them do what they want, write them a check, go on your business, and do what you can do to save humanity and help your fellow brother. That's what I see, I know that we all want to fight the fight and do what is right, but the thing is, The only one that's going to see the victory is you.
Well, that's it, and much of it comes from nourishment, and that's what we need, and that's what the China close off like. You know, the China make it almost impossible to get nourished.
Well, thing is, all they're doing is getting you caught up in their system. This is my slant on it. You know, once we get into this account, we can go out and do our Father's work and help as many as people as we want. If they want, money, give it to them. Who cares?
But you're basically already in the Master Trust. That belongs to you. It's just, it's never been expressed. And there are certain ways to express it. You can't express it publicly because it doesn't exist publicly.
Well, you don't want to have the controversy. You take away the argument. Once the argument's gone, that's what this trust thing is all about. If you really look at it,
Michael, your goal is to go in there and correct your IMF file, correct?
That's what the goal is. I do the IMF file, then I turn around and maybe as a group we do the launchment attached to the Declaration of Independence, and then we express it and then leave an opening there, because I think once a few people get in there, they're going to close it down. They're not going to allow. They're only going to allow a few people in. That's my thought, Michael. And the thing is, yes, sir.
What happens? I mean, what if you take somebody that's pure and they don't have any of this stuff? In other words, they don't have a birth certificate.
My daughter has that, and once CW said it tonight, is once you get into your account, you can turn around and you can will that to anybody.
No, but I'm saying, I mean, you don't see a benefit of a man or a woman or a child that doesn't have all that stuff from the beginning of their existence? You don't see that there's not another trust in nature under our Creator?
A lot of gypsies live like that, don't they? They're just people of the land, and that's how they live. And a lot of
that's the way we're supposed to be. We're of the land or of Scripture, whatever you choose to be. If you want to worship the moon, worship the moon. I don't care.
Well, the grandson chooses his own law form.
Absolutely, and this is where, my daughter is not in the system. She's never been in the system. And the thing is, I'm going to keep it that way. And the thing is, her inheritance comes from me. And if she chooses to walk into that arena and get all the paperwork that they want, then she can do it. But I'm teaching her what that involves and what it's going to do to her on a personal level, where she's going to be a slave. And she's not going to be free under the laws of our fathers.
Well,
and the thing is,
I have 4 children that don't have that.
Well, you were a wise man. There's very few people that have done that. I only know of 2 other people.
When I was in the Moscow International Airport about 5 years ago with one of my daughters.
Well, I've heard this story. I've heard what you said, and I want to stay on track here, and I'm not trying to be rude, Jake.
Yeah, that's fine, Michael.
This is my thoughts on this is that once we do the Declaration of Independence, there's going to be a small group, and then a launchment. This is my personal thoughts here, is that these individuals, if they choose to get into their account, they have to pay us back. Now, whether that is just us saying, okay, you have to read this book, and then you can get into your account. And the thing is, we tell Miss Rios they have to get an okay through us, because that's basically what the Founding Fathers did. But they left an open door. And what my thoughts are is basically put in an addendum to the Declaration of Independence, because the Declaration of Independence is worldwide. And I've said this before.
Worldwide?
It's worldwide. If you look at that, it's all men are created equal and endowed by their Creator. Now, the reason why they put the word Creator in there, because there was controversy back then about what was the Creator's name, God, Yahweh, or Adonai. So
there is no name.
That's right.
That's the problem.
There is no name.
There is no name. When you stand in His presence, you'll know that there is no name.
Well, I mean, Yahweh, which is Hebrew, as you well know, means I am that I am. That's not a name.
No, it doesn't, Michael.
Well,
when Moses stood in the presence of the light and the fire, in the form of the so-called burning bush, there was an ancient Hebrew utterance, never the words that you're saying. And they construed that word out of the utterance. But it's not a language. It was E-A-U-A. When Moses asked, who shall I go tell them, sent me to do this thing, the light and the fire responded, tell them that E-A-U-A sent you.
I understand that, but I'm just saying it on a simpler level that everyone can stand, because a lot of people can't get into the deepness that you know, and we have to keep it on a level that everyone can understand. I understand what you're saying. What you're saying is true.
He tried to do that, and look where we are. He mixed pagan and the truth, and here you have everybody in a cloud under creditor-debtor.
And this is what our objective is. We are of like mind here, and we have to come to a consensus.
Okay.
Otherwise, I think we're going to be fighting each other, or we're just going to do it we're just going to do it on our own and mess everything up for everybody else.
Okay.
And so, we can. The old Christian saying, we can agree to disagree. But we have to get a basic understanding of what our true objectives are. And this is my thoughts. I might be out there in left field and everyone disagrees with me.
Hey, Michael, I appreciate that. And everybody, I'm signing off, but thanks for tonight.
I agree with you. It's very, very late.
It's 6 a.m. in the morning in England.
Of course it is.
Thanks for your contributions, Pete. They were great.
Thanks, Pete. Thank you all. Good night.
Thanks,
night,
guys.
night.
Good night.
Michael?
Yes, sir.
Do you know anybody that's done what you're, do you have any proof that you can do what you're thinking about as your goal?
Well, my thoughts on that is that
you're too smart not to have proof.
Well, yeah, my proof is Scripture, and I read and I just see it there, and it's just Scripture is nothing but a bunch of trusts put together, and it's just common sense. And the thing is, you got to look at the people before us. They were moved. I'm just being moved of what I studied and everything else. I don't have any proof. I just have a gut feeling, and that could very well be the big man upstairs talking to me, which I tend to believe. I'm just going with a feeling. This is a very, very, very earth-moving thing about what we're about ready to do. And I don't think people have the understanding of how deep it really is. It could be, it could free all of us.
Yeah. My strategy, if you want to know, and I thought about this to see if this is real, I would have to, under being responsible, I would have to be able to prove to myself that the direction that I'm going in is guided by the clouds by day and the pillar of fire by night. I would need physical proof. And so that's why I asked earlier tonight is if there's a way that we had a questionnaire that could be sent to the IRS that we could get answers so that we could set up the possibility of going in there and correcting a record and actually taking control of it or terminating it and creating a new one like CW talks about.
Well, the only problem with that, if you let your adversary know what you're going to do, he can put up bulwarks to stop you. And that's the only objective I see on that. And the thing is, they're not going to answer you. I've tried. I have written to, the head of the banking institute, the IRS, everything. And you don't get a response back to those people. What you have to do is, like he says, create a record, submit the
unless
record.
your bloodline.
What's my bloodline?
No, I said unless your bloodline. If you're in the bloodline, you can get to these people. You can get to the proper people to get some kind of, I don't know, proof that the direction you take is straight ahead. It's not just a total guess. That there's some kind of evidence that's leading and guiding and directing you to go on the right path.
Well, the thing is, from what I've seen, they have a reserve. Well, how can I say this? There are families that are running this planet. Okay.
Yeah.
As you well know, and they are waiting for certain people, individuals, to step out. And I think once they see the paperwork done in the right way, they will recognize it. And it's just the way that we word the documents colorfully, where we're not exposing their brilliant plan. And we go on under the radar, and I think it's going to work. I just have a feeling, and it just has to be or done where the words are colorful, the documents are done right, and I think it's going to be a very few people that are going to be allowed in. Now, whether that's done through bloodline or whatever, that remains to be seen.
Yeah.
Because the thing is, the new priesthood there's no bloodline under the new priesthood. And the new priesthood is each man going under what Scripture tells him to do by his own studies.
Yeah. Well, do you think there's a way that you can, I've been out of the system a long time.
I've been out for 9 years. I'm not in it.
Yeah. I've been out my whole life, about 50 years. I incidentally got a little bit, put my foot in the wrong water at once or twice, and I got right back out, so I didn't get hammered at all. So I think I have a really clean IMF, by the way. I was wondering if you do a FOIA report. The other thing